Hi, are you ready? Can you hear me? Sound check. Can you hear me, Sizwe? Okay, right. Let me just do it once more. Can you hear me? Are you getting me? Sure.
this mic doesn't work. I'm just moving to another one. Good morning, everybody. Morning, all the members. Thank you very much for being here on a Friday. As you know, we have a short agenda. It doesn't mean, however, that we're going to be done quickly. I think everybody received the copies of the legal opinions, and legal services are very kindly going to take us through the opinions from the legacy submission. So I propose that they take us through their opinions, and then afterwards, if there are any questions, we can ask them for purposes of clarity. You can ask questions on the opinions. As far as deliberations go, the committee will meet on our next date to deliberate on the legal opinions. We won't need to waste the time of legal services with that meeting. So if you have questions today, please ask them. Pilot, are there any apologies?
Yes.
Thank you, Chair. Good morning, members. I've got apologies from Honorable Dlamini, Honorable Ngola, and Honorable Mutambi. Those are the three that I received.
Thank you very much. This is the first time, really, that this committee is sitting with most of its members present. So may I ask that we just quickly go around the room and everybody introduce themselves. I don't know everybody by name. I would like to learn all of your names and get to know you by name. So I think everybody knows the two chairpersons. If we could start with the legal advisors and just move around the room. Thank you so much.
Good morning, Honourable Chairpersons, Honourable Members. My name is Frank Jenkins. I am from the Legal Services Office, Senior Legal Advisor in Parliament. Thank you.
Good morning, Chairpersons, and good morning to all honourable members. My name is Bulelani Simani from Legal Services Office. Thank you.
Good morning, Chairpersons. Good morning, honourable members and colleagues. My name is Buisekam Tati, Parliamentary Legal Advisor from Legal Services. Thank you.
Good morning, members and everyone in the platform. My name is Phumelele Ngema, also from Legal Services. Thank you.
Good morning, chairpersons, honourable members and all of our colleagues. I'm Fatima Ibrahim, also from the CLSO.
Good morning, chairpersons, honourable members and colleagues. My name is Adla Arnold and I'm from Parliamentary Legal Services. Thank you.
Good morning all. I'm Tracy McGiven. I'm also from Legal Services.
Member Pinar from the NCOP.
Good morning, everyone. I'm Kathy Labiskachny, a member of the committee.
Good morning. My name is Virgil Harika and I'm from the NCOP. Thank you.
Good morning, Chairs. Good morning, honourable members, as well as the officials. I'm Desiree Finis, member from permanent delegate from the NCOP.
Good morning, co-chairs, honourable members and colleagues. I'm Kolis Kaunda, permanent delegate from KwaZulu-Natal, NCOP. Thank you.
Good morning, everybody. My name is Mandla Peter. I'm from the NCOP, a permanent delegate from Eastern Cape. Thank you.
Good morning, chairpersons, colleagues, members of the committee. My name is Sakina Frenchman, and I'm a member of the committee. Thank you.
Good morning to the co-chairs and to the honourable members and the officials. My name is Alexandra Abrams, and I'm from the National Assembly. Thank you.
Isahlope, the MK Party. Thank you.
Morning, everyone. I'm Zintle Khalek, support for the IFP.
Good morning, everybody. My name is Sisanda Sipamla, and I'm from Committee Section and the Content Advisor of the committee. Thank you.
Good morning, everybody. I'm Zoraina, Executive Secretary to Mr. Pat Sibande.
Good morning, everybody. Secretary to Advocate Breitenbach. Ismay, thanks.
Good morning, Chairpersons and Honourable Members. I'm Clara Williams. I'm a Parliamentary Legal Advisor. Thank you.
Okay, is that everybody?
Morning, honorable members. I'm Zukiso France, the committee assistant. Thank you.
Good morning, everybody. I'm Pilot Gwebo. I'm the committee secretary.
Okay.
Yes, good morning, everybody. My name is Pat Sibande. I'm a co-chair.
Okay, everybody, thank you very much. Let's get started. I think Mr. Jenkins is going to kick off, so let's get straight to it. Thanks very much.
Thank you, honourable co-chairs. I am going to kick off. My team will follow. Not all of us could make it today. So the opinion I'm starting with is from my colleague Andile Tsechane, who's unfortunately busy with a different panel today. And thereafter we'll go down and do our opinions. I've got two more coming at the end from another colleague that's not here, Ms. Theloshni Gangan. So the opinion I would like to commence with, honourable co-chairs, is our reference 190/2023. That's dealing with, I think the committee reference would be...
Sorry. Yes. No, I don't believe they've been printed for all the members. You should print them for yourselves. That's why they were emailed. No, we certainly don't. In the Justice Committee, we don't. No, they haven't been printed for every member. Members are required to print them for themselves. Are there any spare copies, Pilot? No. Who needs them printed? 1, 2, 3, 4. Could you do me 4 copies, please, Esmeralda? We'll start so long. Try and follow on your cell phone. But in future, please make sure that if you want hard copies, that you print them before you come.
Good morning. Thank you. You must make provision for people with visual impairment. This is why I'm requesting a copy, number one. And number two is then for us that did not attend the first meeting, we have received the agenda and so on. But can you just give us a brief explanation as to where we are? Are we dealing with a legacy report exclusively, or what do we do here today? Thank you.
I think everyone received a copy of the agenda electronically, and it's very clear that we're receiving a briefing by the Parliamentary Legal Services on legal opinions from legacy submissions. So that's what we're doing here today, as stated on the agenda. Thanks, Mr. Jenkins.
Thank you, Honourable Co-Chair. So the opinion I would like to start off with is from the African Criminal Justice Reform, but the reference number is 190/2023. And it deals with Section 179 of the Constitution, which is the provision for the appointment of the National Director of Public Prosecutions. The submission itself says that the appointment of the National Director of Public Prosecutions is, of course, according to Section 179(1)(a), in the hands of the President as head of the Executive. And the President approves or appoints the National Director of Public Prosecutions. The submission argues that the National Director of Public Prosecutions is in charge of a very critical institution in South Africa, which basically, according to their submission, is the custodian of accountability, because they decide who to prosecute and who not, and to run those prosecutions. However, according to the submission, at least 14 positions is appointed by either the President or the Minister of Justice and Correctional Services. And the submission is that that's a over-concentration in the hands of the executive, and there should be more details in the Constitution about the appointment process, the qualifications that's necessary. That's the first part of the submission. The second part of the submission is also the removal of the National Director of Public Prosecutions, which is dealt with in the NPA Act, should be in the Constitution. And there it should mirror more or less the grounds for removal, as is the case with the President in Section 89, as well as with the removal of certain of the commissioners of the Chapter 9 institutions. And then it referenced the process that Parliament had in respect of Mr. Advocate Vusi Pikoli, where that ad hoc committee also noted to say that it is an anomaly that the appointment happens through the President in the Constitution, but the removal is at the initiative of the President, but then Parliament plays a bigger role in the removal, but Parliament doesn't play any role in the appointment. So based on that argument, the submission then, the opinion then analyzes or looks at Section 179. And when it analyzes Section 179, it starts first by saying, and this is more or less the system at legal services we use. We've tried to look at if this matter was raised during the certification judgment. And this matter was raised during the certification judgment. There was a challenge to 179. The challenge was that it breaches the separation of powers. But the Constitutional Court found in that argument that the National Director of Public Prosecution is not part of the judiciary. So there's no breach of separation of powers. And even if the National Director of Public Prosecutions or the NPA was part of the judiciary, the court said that there's nothing in the mere appointment by the President that will make it fall foul of the principle of separation of powers. I might just add that it's the constitutional principle 6, which requires that there's a separation between the judiciary, the executive, and the legislature. So the court found in terms of that the constitutional principle was not breached, and it rejected the argument. The opinion further then looks at the removal aspect of the National Director of Public Prosecution, and it referenced the Simelane case, the Menzi Simelane case, which went to the Constitutional Court. And that case turned on what's written in the NPA Act about the appointment of the National Director of Public Prosecutions, namely that the person must be fit and proper and legally qualified to practice in any court in South Africa, and that's it. But obviously the submission says that needs to be expanded further, and to find a reference point or a hook to hang that argument on, it referenced Section 195 of the Constitution, which sets out all the characteristics and the principles that must be pervasive in the public service. And the submission says that is a good starting point to say that the person should fit into that, and that should be then an amendment in Section 197 of the Constitution. So, Chairperson, basically what the submission recommends is that there must be a removal procedure along the lines of what has now been developed. And one can add here, and the opinion looks like that, the removal of the President and the removal of Chapter 9 body, for instance, the Public Protector, Parliament went ahead and provided detailed rules for that process. And in terms of that process, there is, of course, it starts with a substantiated motion that's approved in the House. If that complies with all the requirements of a substantive motion, it's referred to a panel, an independent panel, which does a fact-finding mission and reports back to the Speaker, or to the House through the Speaker. And there is then a motion in the House whether that report is then accepted. And if it is accepted, it goes to the impeachment committee, which does the examination of the facts, the verification, and then makes a recommendation to the Houses. And that, the submission says, is a good example of how we should deal with removal of the NDPP as well. Chairperson, We at Legal Service don't usually argue for or against these submissions. That's not our duty. Our duty is to advise the committee. The opinion does that, but the opinion does then, I think, in assistance for the committee to make a decision whether they want to go more into more detail in this matter and to consider it further, refers to certain statements of the former Deputy Chief Justice, which also speaks of the unduly concentration of appointment powers within the head of the executive. As chairperson, I would like to leave it there, but of course we've seen now what happens in other democracies in the world with concentration of executive power, and our executive power is not as they did in the 17th century. Let me put it that way. So there is a matter, it's a debate that one can look at. Is there an unduly concentration of power in the head of the executive in South Africa? There's no comparative analysis done in the opinion. That was not our duty. We just look at the submission and advise the committee. But that is where one will go when we want to look further into it. So, Chair, that's in a nutshell. Thank you very much.
Thank you. Mr. Jenkins, might I ask you, before we take questions, if there are any, bearing in mind that not all the committee members are not all lawyers, and that's a good thing, because we want a variety of approaches brought to bear on all of these submissions, and not just that clinical approach of lawyers. Could you briefly, very briefly, just run through the concept of the separation of powers? So, just briefly.
Thank you, Honourable Chair. Certainly. The separation of powers, I mentioned the constitutional principle where it was captured. It's not spelled out clearly in our own constitution. Constitution does provide that the state of South Africa consists of the judiciary, the executive, and parliament. I should actually say parliament, the executive, and the judiciary if we're sitting in parliament. But whichever way, those are three separate branches of government. The principle of separation of powers works that the authority of the state is separated between these three. So the judiciary will decide whether there was a breach of an agreement or whether there was a breach of a law. The parliament will make those laws and the executive will implement them. In the Constitutional Court has said or found that the principle of separation of powers in the certification judgment that it's not a static concept, it's an evolving concept. So different countries have different styles of separation of powers as well as the checks and balances. The checks and balances is again to control the power in the other sphere. For instance, Parliament can hold the executive to account, including having a say in the judiciary as well as the appointment. The executive has certain powers to check Parliament, and that we'll see today when it comes to money bills. So only the executive can introduce money bills, which is a type of check on the legislative power, in my opinion. So the judicial power is again checked with certain jurisdictional matters. The Constitutional Court has certain specific and exclusive jurisdictions, and so with the High Court, the Supreme Court of Appeal, and the Magistrates Court. So it's in that way that we try to balance the power, and it's based on the principle that power corrupts, absolute power corrupts absolutely. And it comes from, I think, 17th or 16th century French philosophy. I'm not going to, I mean, I find it, I'm not going to bore you with it, but I can't quote all of these things now. I used to do that, and it's not there. So each country will have its own type of separation of powers, and ours more or less looked at the German and the Canadian constitutions, if I remember correctly, when this constitution of ours was drafted. So, Chairperson, in that regard, this submission, which looks at Section 179, touches on the separation of powers, and it's a very interesting question for me. Might I say that this is a matter that the committee can look at? We will get other matters, also what I will be briefing the committee on later, where we would say the submission doesn't really need to be a constitutional amendment. There's already a court case that deals with this matter, or that is, they're asking for a change in a normal statute, not the constitution. So we will get different requests from the public. But this one is specific to the Constitution, and in fact wants to take a statutory provision, namely the removal of the NDPP, and put it into the Constitution. Of course, the constitutional amendment has a specific process. So that is where it is. But that principle that you asked me about, Chairperson, is, I think the best way to describe it, as the court also said, it's moving, it's not static, it's unique to a country. So it's critical, and we've had court judgments where that principle was applied and said that it's unconstitutional because of a breach of separation of powers. For instance, and the opinion refers to that, there were two challenges to the NDP Act. One because of, and maybe you recall, the power of the president to extend the service of the NDPP beyond 60 years, 65 years. And the court said that breaches the separation of powers because that creates the impression that that NDPP, when it turns 64, 64 and a half, 64 and 3/4, will start playing along with what the president wants and not be independent anymore and not have that checks and balance on it. So let me leave it at that, Chairperson. Thank you.
Thank you very much. Members, are there any questions on this particular?
Thank you, Chairperson. Sorry, this is a very interesting debate and very fine line if it comes to the separation of powers and the powers of the president in this regard. My understanding of the doctrine on the separation of powers is to prevent or avoid an overconcentration of too much power in one body. That's the gist of it. So if you have the president to appoint, for instance, as you've pointed, I don't know when this judgment has been delivered. I'm not updated on this, but by the Constitutional Court. I don't know. Do you have, maybe have a date through the chair? Because as you say, it could be progressive, you see. It's not static.
That's 2018. Corruption Watch, NPC, and others versus the President of South Africa. Nkasana versus Corruption Watch. 2018, Constitutional Court.
Thank you.
13 August.
Thank you, Chair. So it's a fairly fresh judgment, though. If we discuss the separation of powers and we look at the role of the president, the appointment, the signing off of the appointment and so on, you don't want those positions to be compromised. You need to take into consideration the independence and the objectivity of the Office of the National Director of Public Prosecutions. So yes, we understand that you can say there's no interference or whatever you have said in your introduction, in your preliminary introduction, but we are all aware that those officers, or we have long opted to say those officers or the powers of those officers need to be separated for simple reasons. The office of the NDPP also accounts to the Minister of Justice. So the Minister of Justice is a political office bearer in terms of our legislation. The Minister of Justice, although he's the Minister of Justice is aligned to a specific political party. Doesn't matter who's in charge at that time. So the independence is here under question. This is the main thing, the independence, because you cannot lay a submission or bring a submission or a charge before the NDPP. The NDPP must now decide, but must take it to the same people that are most probably implicated by extension of party or by extension of political affiliation, for that matter. So that's problematic to us. It brings the independence, the objectivity into question. You can never be secured that there will be a fair or a just decision or resolution on those charges. And therefore we say those officers must be, we've discussed it the other day with the Justice Committee, with the NDPP, they have, Chairperson, they have undertaken to bring an independent opinion to that committee with regard exactly to the separation of powers and to see how future legislation could be written in order to make sure that those officers do not encroach powers. But the other argument that came up is that if it cannot be a constitutional amendment, then we need to look at the regulations or even policies that guide those appointments and also the independence. This is just our submission at the moment. We can discuss, deliberate, and disseminate the information further. Thank you.
Thank you, Mr. Gericke. The points you raise are important points, and the opinion would be very interesting for us to look at when you get it. Might I just remind members that we want to only put questions to the legal advisors about the content, questions for clarity. The deliberations for committee members will take place at the next meeting. Thank you.
Chairperson, through you, thank you very much for that question. It actually prompted me to just go a little bit deeper into the submission itself, because that is what the submission is saying. It's saying, well, why is Parliament's role subservient or so subservient? Specifically around the initiation of those proceedings. So the submission wants that to be addressed. My view of how to address it is that, much like in other legislation, someone needs to take responsibility to initiate, whether it's for appointment or dismissal. And if the President is the appointing authority, it would be good for the President to initiate it. But according to the submission, there's two things I want to say about that. And the submission says that, like I've indicated, we need grounds for removal, like with the removal of the President. And if one has that, and this is where my legal opinion comes in, if one have proper grounds for removal, even though the President initiates it, Parliament can at least, or somebody, a political party, can challenge the non-initiation of a process if they are convinced that those grounds have been breached. Much like if a political party feels that there's not an impeachment against the President is not happening. But of course, there they can initiate it through the substantive motion, so that won't be a good example. But that's definitely an area that they're looking at. The submission also says, similarly to that removal and getting proper grounds for removal, that a court can then review if a decision is taken or not taken. So the appointment must also be written down in more detail. And I need just to say there, because the submission refers to it, the present NDPP was appointed by the present President, but through a public participation process, not just through headhunting. So there was a process of trying to get recommendations and having interviews, and that, the submission says, is a good example. But it can't be left to the discretion of a President. That should be in the Constitution. But your question specifically, yes, I mean, what one can ask is, how can we challenge the non-decision if the President feels that I do not want to remove this person? And that's an interesting question. Thank you.
Thank you, Mr. Jenkins. Any other questions on that particular?
Yes.
I think the answer is partly correct in the sense that the question, as I understand it from my esteemed colleague and from my colleague from the FF, is that the problem is this. At the moment, the law allows the president to initiate the process, and he's the one who does the appointment. This is similar to the appointment of the Chief Justice, I think in terms of Section 174 of the Constitution, where the president nominates a candidate and he does the appointment. That, we are saying, is problematic because you are concentrating too much powers in the hands of the president. It should not be the president who does the initiation, who brings the name up forward for consideration. We must find another way of doing that. It's highly unlikely, in other words, that the president would support a candidate to be a national director of public prosecution, and that same president would remove that candidate. It will never happen. That is really the point that we're making. Thank you so much, Chairperson.
Thank you, Dr. Slorper. Anybody else have a question on this particular opinion? Okay, thank you, Mr. Jenkins. Mr. Sibani.
Chairperson, I wanted just to make a comment. I'm not asking a question, just a comment. Because we agreed that some of the deliberation will come after to us as members. See, from your own input, you indicated that you put an example that each and every country, they've got their own separation of powers. And then secondly, to us, I feel that in our next discussion, we ought to concentrate in terms of a transformation. If we look this matter in terms of, must look in terms of transformation, how to assist our own. Because most of the time, we're very far from some of this. And then also, to concentrate on the domestic matters. No matter if we agree that we must go and consult and check and lend to some of the countries. But concentrating to domestic matters, I think is more valid and powerful. Unlike, I don't want to regret my term in the office, whereby we'll create something when I left and started to regret. So that is my comment. And then also, you indicated that, I don't know whether you have started, but I could pick up when you were indicating that you refer to Germany and don't know in which country which you consulted. In terms of other democratic countries, or countries which have democratically elected. I don't know how far is it. And then also, in terms of a checks and balance, I propose that whenever we check, we mustn't check internationally to Western countries only, while we do have only democratic elected countries, even in Africa. Our own state, like which country, so that we can balance our thing. When we take a decision, we take a correct decision in terms of what we want. Because I believe as we are here, no matter we're from different political parties, but at the end, we are the ones who represent the people in our constituencies. So that is my take, Chairperson.
Thanks, Mr. Jenkins. Can we move on to the next opinion? Thank you.
Thank you, Co-Chairpersons. I'm going to present an opinion that is referenced 189 of 2023, which is a submission from Sakelicha, which is a business, a business group and a public benefit organization, which represents more than 12,000 members in various enterprises from small to big businesses across South Africa.
Closer to the mic, please.
Oh, sorry. I was saying I'm going to present this opinion, which is a submission in relation to the submission received from Sakeliga, which is a non-profit organization representing businesses, about 12,000 members across South Africa. The submission proposed that the Parliament of the Republic of South Africa should abandon any process of amending Section 25 of the Constitution, at least in the current form that is being considered. In their submission, Sakeliga states that the current provisions of the Constitutional Amendment Bill do not advance the human rights and freedoms as the requirement of the South African constitutional state in Section 1. Perhaps you can just refer to that specific section in the Constitution, which reads as follows. The Republic of South Africa is one sovereign democratic state founded on the following values: human rights, human dignity, the achievement of equality, and the advancement of human rights and freedom, non-racialism and non-sexism. C, supremacy of the Constitution and the rule of law.
Excuse me, Chairperson. Can we please have the reference number of that document?
It's
It's
Section 1.
the reference number of the opinion is 189
189
of
of
2023.
2023. CRC 1 of 2021. Oh, sorry about that. Furthermore, Sakeliga further submits that the amendment bill reduces and weakens the protection of rights, and if the Parliament wishes to continue with the amendment of Section 25, it must reformulate the amendment bill to strengthen, not weaken, the protection of property rights. In support of its submission, it further noted that the government has not paid adequate attention to Section 1 of the Constitution, which I have just read now. The recent proposal, such as the Sport and Recreation Amendment Bill of 2020 and the Constitution 8th Amendment Bill, seek to deprive rights and expand the state's command over individual freedoms and property rights. Section 1A, read with Section 22, that is freedom of trade, occupation, and profession, and Section 1C, that is the rule of law, must permeate any legislation and regulation promulgated by the government. Proposals such as calls for nil compensation with expropriation and proposal that weaken property rights of individuals and institutions of civil society can never be reconciled with a sound constitutional order. Furthermore, they made submission that they recommend that the process for an amendment of the Constitution must first be screened for its adherence to constitutional principle. If it does not, the officers of the Parliament must actively ensure that such proposal does not move beyond the conceptualization stage. While we consider the legal framework, I'm not going to read the entire section, but I want us just to zoom into Section 74, which is of relevance for this purpose. Section 74(1)(a), which reads as follows: Section 1 and this section may be amended by a bill passed by the National Assembly with a supporting vote of at least 75% of its members, and the National Council of Provinces with a supporting vote of at least 6 provinces. What this section actually shows is that our Constitution has actually entrenched these rights that are being complained about, that they are being eroded. It actually sets out specific procedures and majorities that are required to change any of the provisions of the Constitution. We also look into Section 25, which is the subject matter of this submission, which reads as follows: no one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. property may be expropriated only in terms of law of general application. Perhaps if I may just zoom into subsection 2A, which says property may be expropriated only in terms of law of general application for a public purpose or in the public interest, and subject to compensation, the amount of which and the time and manner of payment which have either been agreed to by those affected or decided by or approved by a court. That is the relevant section in the Constitution that we considered. Also of interest is for the purposes of this section in subsection 4 of section 25, which reads as follows: for the purposes of this section, the public interest includes the nation's commitment to land reform and to reforms to bring about equitable access to all South Africa's natural resources. And property is not limited to land. The state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land and equitable. Once more, Chairperson, as my colleague also elaborated further on the doctrine of separation of powers, which I think he has clarified, it is one of the foundational values of the Constitution and provides for a system of checks and balances between the three branches of government aimed at strengthening democracy. Constitutional principle number 6 obliges the Constitution to have a separation of powers between the legislature, the executive, and the judiciary, with appropriate checks and balances to ensure accountability, responsiveness, and openness. In order to entrench the fundamental human rights and the rule of law, Section 74 of the Constitution requires special procedures involving specific majorities required in order to amend any section of the Constitution. I think, as I've already indicated, for amendment of Section 1 of the Constitution, it will be required that there must be at least 75% vote of the members of the National Assembly and at least supporting vote of at least 6 provinces for that amendment to pass the constitutionality. And similarly, in relation to other provisions in chapter 2 of the Constitution, the special requirement there is that at least 2/3 of the votes of the members of the National Assembly will be required, as well as the supporting vote of at least 6 provinces. Those are those special majorities and procedures that are required to effect any amendment in the Constitution. In essence, Section 674 of the Constitution provides a legislative framework to be followed by the National Assembly in making any amendment to the Constitution. The certification judgment provides a solid foundation for an understanding of the South African constitutional framework. The Constitutional Court was saddled with an enormous and unprecedented task to consider whether each of the provisions in the then interim Constitution complied with the 34 constitutional principles. In the first certification judgment, the Constitutional Court declined to certify the Constitution on the basis that it did not comply with all 34 constitutional principles. The Court noted that several provisions of the new text, that is the new Constitution, which did not comply with constitutional principles, which included, among others, Section 74 of the new text. It was argued that Section 74 failed to comply with constitutional principle number 15 in that amendments of the new text did not require special procedures involving the special majorities as contemplated in constitutional principle number 15. The objection was predicated on the fact that 74 provided for special majorities but not for special procedures, which therefore necessitated an inquiry by the Constitutional Court to determine what is meant by special procedures involving special majorities. The court held that special procedures refers to the provision of more stringent procedures when compared with those which are required for other legislation. The Constitutional Court contended that Constitutional Principle number 15 draws a clear distinction between procedures and majorities involved to amendments to ordinary legislation on the one hand and to constitutional provisions on the other. The court held that the purpose of this distinction referred to above is to ensure the new text, the new text, the supreme law of the land against political agendas of ordinary majorities in the National Assembly. Furthermore, in the first certification judgment, the court ruled that Section 74 of the new text failed to comply with Constitutional Principle number 2 in that no special procedure were provided for amending the Constitution as required by this principle. Constitutional Principle number 2 reads as follows: everyone shall enjoy all universally accepted fundamental rights, freedom, and civil liberties, which shall be provided for and protected by entrenched and justiciable provisions in the Constitution, which shall be drafted after having been given due consideration to, among others, their fundamental rights contained in Chapter 3 of the Constitution. Now, in response to this first certification judgment, the Constitutional Assembly amended the constitutional text in such that the amended text now prescribes procedures that must be followed in passing amendments to the Constitution. In the second certification judgment, the court expressed its satisfaction that the procedures prescribed by the amendment text meet the requirements of Constitutional Principle number 15. And in the circumstances held that the amended text complies with constitutional principles insofar as it requires special procedures to be followed for constitutional amendments. It is noted that the submissions from Sakeliga NPC bewails what it terms an anti-constitutional process pursued by Parliament in amending Section 25 of the Constitution. Sakeliga also avers that the current provision of the amendment bill do not advance human rights and freedom as the requirement of the South African constitutional state in Section 1A dictates. On the contrary, Sakeliga submits that the amendment bill reduces and weakens the protection of rights. Chair, if I may refer to a Constitutional Court judgment in Agri, South Africa versus the Minister of Minerals and Energy. The Constitutional Court set out the approach to be espoused when interpreting Section 25 of the Constitution with reference to expropriation. I quote, to have to regard to the special role that this section has to play in facilitating the fulfillment of our country's nation building and reconciliation responsibilities by recognizing the need to open up economic opportunities to all South Africans. The court added that this section thus sits at the heart of an inevitable tension between the interest of the wealthy and the previously disadvantaged, and that tension is likely to occupy South Africa for many years to come in the process of undertaking the difficult task of seeking to achieve the equitable distribution of land and wealth to all, end quote. Mogoeng CJ further stated the obligation imposed by Section 25 not to overemphasize private property rights at the expense of the state's social responsibilities. While the court recognized the individual property rights, it was also alive to the fact that individual property rights are not absolute. A similar view was expressed by Justice Ackerman in First National Bank of South Africa versus the Commissioner of South African Revenue Services. In reference to the provisions of Section 25 of the Constitution, the learned judge remarked that the subsections which have specifically to be interpreted in the present case must not be construed in isolation, but in the context of the other provisions of Section 25 and their historical context, and indeed, in the context of the Constitution as a whole, subsections 4 to subsection 9 all in one way or another underline the need to form and aim at redressing one of the most enduring legacies of racial discrimination in the past, namely the grossly unequal distribution of land in South Africa. The details of these provisions are not directly relevant to the present case, but ought to be borne in mind whenever Section 25 is being construed, because they emphasize that under the 1996 Constitution, the protection of property as an individual right is not absolute but subject to societal consideration, close quote. The above constitutional court cases are in accord in regard to the need to strike a balance between the protection of individual property rights on one hand and the state's social responsibility on the other, particularly the constitutional obligation to open economic opportunities to all South Africans. Moreover, both cases confirm that individual property rights are not absolute but subject to societal consideration, in sharp contrast to the views espoused by Sakaliga NPC in its submissions. We note the recommendation by Sakaliga that any proposal for an amendment to the Constitution must first be screened for its adherence to the broader principle of constitutionalism. The procedure for an amendment to the Constitution is clearly set out in Section 74 of the Constitution, as stated above. This section prescribes the procedure to be followed when making any amendment to the Constitution, and failure to adhere to the prescribed procedures will render the purported amendment to the Constitution unconstitutional and therefore invalid when declared by the Constitutional Court pursuant to the provisions of Section 172 of the Constitution. The special procedures and special majorities required for an amendment to the Constitution, as set out in Section 74 of the Constitution, provide a safeguard to ensure that the provisions of the Constitution are less vulnerable to amendments than an ordinary legislation. This was clearly demonstrated when, in December 2021, the National Assembly failed to pass the Constitutional Eighth Amendment Bill. During the debate, the National Assembly was unable to garner the 2/3 required to pass the bill. During the debate in the National Assembly, 204 members of Parliament voted in favor of the bill and 145 members voted against. In closing, in view of the above facts and discussion, there is nothing unlawful or unconstitutional about the envisaged amendment to the Constitution. And therefore, notwithstanding the submissions from Sakaliga, there will have been no need to abandon the process of amending Section 25 of the Constitution. The Constitution provides for the necessary mechanism to ensure that any amendment to the Constitution does not depart from the same framework set out in Section 74 of the Constitution, which gives effect to Constitutional Principle number 15. Thank you, Chairperson.
Thank you, sir, for that very comprehensive opinion on a very important subject. Members, questions on the legal opinion, but please bear in mind that this is a matter that we're going to deliberate very fully at our next meeting, and I'm sure that everyone will have views and important views on it. But please try not to air those views today, because that is not the purpose. If you have questions on the opinion, please ask them. Any questions?
Chairpersons, apology. I think it's going to be impossible to ask questions on the opinion without going into the detail of the merits. I'm talking for myself. So it's good that we have the opinions here. This is a very critical and important topic. I think we must rather, I would propose that we rather set aside the next session, even though it may be a longer session, to disseminate this information, to go through it. That we just familiarize ourselves with the opinions today as presented by the legal team. And then I think it's for the House to decide whether we're going to defer to the next session for thorough deliberation. But that would be my proposal. Thank you.
Thank you, Mr. Gericke. As we set out in the agenda, today is only for hearing the legal opinions. The next meeting will be for deliberations. No one is expected to deliberate these weighty issues today.
You must excuse me if I repeat, but I did not receive an agenda. I was only added late last night. It's fine. It's maybe just an oversight, but I have spoken to the chairperson, Sibanda, yesterday, and they've corrected that. So
My
thank
apologies,
you.
I was not aware of that.
Yeah.
But you will get all the documents. You will be able to go through them. And if there are issues that arise during the deliberation stage that require the assistance of legal services, we'll let them know, and I'm sure they can come back at some point and assist us. So these are important matters, and they will be traversed fully, and everyone will have the opportunity to engage with them fully. Thanks.
Thank you, Honorable Co-Chair. I think we thought that we are going to also, for today, after all the presentation, include the proposals of our next program. For an example, in our short notes, we indicated that on the 28th March, the committee will be dealing with the deliberation on legal opinion and decision on desirable and submissions. I think it's on the pipeline because we had a date already, of which we wanted to maybe to bring it back to the committee so that the committee agree that this date we are going to take some of this. Thank you, Chairperson.
Thanks. Mr. Jenkins, can we then have the next legal opinion? There appear to be no substantive questions.
Thank you, Chairpersons and honorable members. The next opinion I will reference is Ref number 194 of 2023. Committee reference is CRC 7 of 2021. The opinion deals with the submissions received from Dube Enterprise in response to the JCRC's 2021 annual invitation for public submissions. The Dube Business Enterprise has proposed fundamental changes to the preamble of the Constitution, as well as Chapter 2, which is the Bill of Rights of the Constitution. Their submission is, among others, seeks to amend seeks an amendment to the Constitution for the purposes of replacing the words everyone in the preamble with citizens, and include the following words, which is those who legally live in it. And then in support of their submissions, they have recorded their decisions, their reasons as set out. One of which they said that state resources should only be used to fund, should not be used to fund foreign nationals in order to prevent influx of refugees, asylum seekers, and illegal immigrants. They also propose that South Africa reviews all international agreements which have financial implications to the South Africans, to its citizens, and that those bodies that the international bodies that protect international human rights should be the ones that provide the necessary funding for the non-South Africans. This opinion, therefore, is based on the above mentioned context. We wish to advise the committee that, in our view, some of the submissions received from Dube Enterprise appear not to address substantive. Sorry. Some of the submissions appeared not to address substantive amendments to the Constitution. Should the committee require further guidance regarding such proposed amendments, then we indicate that a supplementary opinion then will be submitted in that regard. There are other issues that are dealt with, opinions which are to be presented to this committee. One of those is relating to traditional law and traditional leaders, the chair and committee and honorable members. Then we set out the legal framework in the opinion, as well as which is the Constitution. And the preamble of the Constitution says that South Africa belongs to all who live in it, united in our diversity. We also deal in the opinion with the supremacy of the Constitution, that our Constitution is the supreme law of the Republic, and any law that is in contravention of the Constitution is invalid. And then we deal also with Chapter 2. We zoomed in on Section 7 of the Constitution, which is amongst other things, the Bill of Rights, which states that our Bill of Rights is a cornerstone. The section enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. We looked also at Section 8 of the Constitution, which indicates that the Bill of Rights applies to all law and binds the legislature, the executive, the judiciary, and all organ of states. We also touch on the opinion on Section 32 of the Constitution, which deals with customary international law and the section provides that the customary international law is applicable in the Republic unless it is inconsistent with the Constitution or an act of Parliament. Further, we looked at Section 39 of the Constitution, as well as Section 173. Section 39, too, indicates that when interpreting any legislation and when developing the common law, customary law, every court, tribunal, or reform must promote the spirit, purport, and objects of the Bill of Rights. And Section 173 of the Constitution deals with the inherent power of the higher courts. We looked at the Refugees Act 130 of 1998 as amended, which was enacted to give effect to the relevant international legal instruments, principles, and standards relating to refugees, to provide for applications for and recognition of refugee status, and provide for the rights and obligations flowing from such status. The preamble of the Act, which is the Refugees Act, recognizes that South Africa has acceded to the 1951 Convention relating to status of refugees, the 1967 Protocol relating to the status of refugees, and the 1969 Organization of African Unity Convention governing the specific aspects of refugees' problems in Africa, as well as other human rights instrument, and has therefore assumed, has accordingly assumed obligations regarding the reception and treatment in its territory in accordance with standards and principles established in international law. We touched briefly on the on Section 2 of the Refugees Act, which deals with general prohibition on refusal of entry, expulsion, extradition, or return to other country in certain circumstances. The Refugees Act upholds both public interest and individual interests by extending protection to those who are unable or unwilling to return to their country of nationality out of fear as set out in the Refugees Act. We then, as my colleagues have already alluded to the fact that we looked, when looking at these opinions, we look at whether these were addressed in the certification judgments. And in the first judgment, the Constitutional Court declined to certify the Constitution as complying with all 34 constitutional principles. It was in the second judgment then the Constitutional Court that it did. The 34 constitutional principles are still relevant today in the interpretation of the Constitution and development of South Africa. It is our view that upon perusal of comments received, we noted that the removal of the words everyone and replacing it with citizen has a potential of not passing a constitutional muster. We touched on the principle of non-refoulement. This principle is a cornerstone of international refugee protection. It provides that no refugee should be returned to any place where there is likelihood that he or she may risk persecution, torture, inhuman, or degrading treatment. We have previously touched on, I have previously touched on Section 2 of the Refugees Act. Having rectified international agreements in that regard, South Africa is obliged to establish systems and allocate resources to ensure the international human rights law protection of refugees and asylum seekers. We mentioned a few cases. I would not go into detail. The first case is Baromoto versus Minister of Home Affairs, which is a 1998 decision. The court acknowledged that international agreements are binding on South Africa. And then the second case is Kiliko versus Minister of Home Affairs, 2007, Volume 4. The court emphasized the state's obligations in terms of the international instruments which it had become party and the legislation enacted by it to give effect thereto. Then we looked also at Section 7, Section 7 of the Constitution that places a constitutional obligation on the state to respect, protect, promote, and fulfill the rights in the Bill of Rights. The last court judgment that we looked at in this opinion is the Scalabrini Center of Cape Town, and another versus Minister of Home Affairs and others. This case, in terms of it's a 2023 judgment. Section 22 12 and 13 of the Refugees Act was declared to be inconsistent with the Constitution and invalid. The court found the impugned provisions to be arbitrary and a violation of core principles of refugee law, and that asylum seekers must be treated as presumptive refugees until the merits of their claims have been finally determined through a proper process. The principle of non-refoulement and its impact on children were also considered in this case. In December 2023, the court, in December 2023, the Constitutional Court then confirmed the Western Cape High Court's declaration of invalidity as they and indicated that the provision violates the principle of non-refoulement, infringe the right to dignity, unjustifiably limit the rights of children, and are arbitrary and irrational. The declaration then was retrospective. For purposes of the current question, it is therefore clear that our courts have deliberated on the issue of refugees in South Africa and the rights afforded to them by our Constitution. It is submitted that the committee may consider, after due regard to the court cases listed in dealing with the submissions from Dube Enterprise, to not support the removal of everyone from the Constitution and to allow the status quo to remain, or to consider whether there is a need for Parliament to look into amending existing legislation dealing with refugees or asylum seekers, or for South Africa to consider withdrawing from international agreements. This is a policy matter that may have advantages and disadvantages, which would need to be interrogated. In conclusion, chairs and honorable members, as indicated, the decision to remove the word everyone in the Constitution may not pass constitutional muster, as our courts, including the Constitutional Court, have deliberated on the issue. The human rights jurisprudence developed by our courts in South Africa is firmly anchored in international human rights law, although there are fewer than expected cases in which the courts have alluded to the instruments which comprise the International Bill of Rights. Further, Section 232 of the Constitution binds South Africa to customary international law, which includes the right to non-refoulement. Then international human rights law lays down obligations which states are bound to respect. By becoming parties to international treaties, states assumes obligations and duties under international law to respect, to protect and fulfill human rights. South Africa is also a signatory to international agreements. The key question then, chairpersons and honorable members, is whether it would be in the best interest of South Africa to withdraw from international agreements. Any meaningful answer to this question, however, requires the committee to engage on these issues and consider the consequences of such recommendations. The committee is advised accordingly. Thank you, Chairperson.
Thank you very much for that opinion. Members, are there any questions on this legal opinion? Dr. Slotberg?
Thank you very much, Chairperson. I just want to ask, this is another sensitive area, right? My question is this: have you come across in your research any country in the world where, in addition to any constitution protecting the citizens and asylum seekers, the constitution goes further and protects people who are there in the country unlawfully? Is there any country in the world that you have come across?
Thank you, Honorable.
Mr. Kanda?
Thank you, Chair. Let me concur with my colleague who have just referred to this matter as one of the sensitive matters in the country, and in the world. The reason why I want to raise this issue is because how we as South Africa define foreign nationals, it somehow becomes a challenge. Maybe we need to be, if it's possible, that we look at it as well, because I'll assume, Chair, I'm not debating, but I'll assume that somebody who comes from Africa can't be referred to as foreign national. But this is what our law says, it's foreign national. So where do we reach a stage where you clearly define an African national from the continent and a foreign national? So the definition on its own, whether it's international, but I think it's also calls for another debate. The second issue, Chair, it will assist us to consider this submission by Dube Business. If you can also bring the immigration amendment section that have been dealing with the set of skills and businesses, that must be the reserve for South Africans. So that when we consider this matter, we'll be looking at it whether it's adequately addressing some of the concerns that Dube have pushed Dube to come up with this amendment, which we are advised that it should not be supported. Thank you.
Thank you, Mr. Nvala.
Yeah, thank you very much, Chair. No, my question is very short, and it relates to making a reference to a statute or to an act when you dissect the possibility to an amendment of the Constitution. Whereas Section 2 dictates that the Constitution is the supreme law of the country. So what is the logic behind making a reference to an act? Because the Constitution determines the standing of the statute or of an act. It is the one that must dictate how the act should look like, or what the act must say based on the constitutional order. So I just want to get a clarity on that. Thank you.
Thank you. Any other questions? Okay. Could you deal with those three questions, please?
Thank you, Chair. With regards to the first question, I haven't, Honourable Member, looked at, in my area, when I was researching, look at any country, as you alluded before in your question. If it is something that the committee would want to pursue further, then our office then will look at that. Thank you, Chair. With regards to the issue about immigration amendment bill, we have also not looked at that. The purpose of the opinion was looking at why they're supporting their submissions, and we didn't look further to that. With regard to the last question, then before I go to the last question, Honourable Member, then if it is something, co-chairpersons, that the committee would want to look at, then we would be more than happy to look into that matter. The reasoning regarding the third question, the reasoning regarding the coaching legislation, because it emanates from the fact that the request or the proposal is saying that everyone, the word everyone, should be removed in the Constitution. Therefore, then there's an act of Parliament as well. Then if we say there must be a removal of everyone in the preamble or in the Constitution, then that would mean that there would have to be an amendment of the Refugees Act, which that's why we touched on the act, because it's in some of their proposals they are saying that we need to not to fund any refugees within South Africa and all those that and that's why we touched on the principle of non-refoulement as well. Unless that principle is inconsistent with the Constitution, then that would be a different debate. Thank you, Chairperson. I'm not sure whether I've answered your question, Honourable Member.
Thank you very much. Any follow-up questions? Mr. Jenkins, I don't know if I should address this to you or to the young lady herself, but it might be helpful if you could, it's not necessary to present it, I don't think, but if you could just in writing advise us on the position of other countries, as the question posed by Dr. Slope, other countries protecting people illegally in the country. And if you could just disseminate the amendment of the Immigration Amendment Act, so that we could just have a look at it. Just send it to all the members so we can read it. If we have further questions, we can raise them, but just that everybody can be fully aware of the content. Thank you.
Thank you, Chairperson.
Then we can move on to the...
Yes, I also concur with my colleagues on what we have requested so that we can be able to know exactly what are the do's and the don'ts in terms of our own domestic matters. Thank you.
Thank you, Chairpersons.
Greetings to both the co-chairpersons and the members as well. Thank you for the opportunity. Chairperson, perhaps with your permission, before I touch on mine, I think just to add on behalf of my colleague on the last question, that another reason we are basically looking at legislation when we're talking to the Constitution, it's in respect of the principle of subsidiarity, that before we can attack the Constitution, we are required to see what the legislation in place is indicating, because the Constitution is merely a general framework, Chairperson. That is just to add on, and thank you for that. But for me, I am basically going to be dealing with two submissions in respect of what was brought to us in 2023 when we had to look at these submissions, and we prepared the opinions thereon. The first one, in fact, Chairperson, both of mine are seeking as well a direct expression in respect of the African law, and that was the opinion that came from TD attorneys, where they were also expressing out what it is that they are not happy with in respect of how African law is recognized in the Constitution. Then the second one, Chairperson, will be on the further expression within the Constitution of territorial waters. So, but I will start first with the first one on African law, which is from TD attorneys, and then move on to the second one. The reference number, Chairperson, that I'm starting with is the one for CRC 3/2021 with our office reference number. It's 191 of 2023. That's the one I will start with, Chairperson. But perhaps in case I miss it for the second one as well, the CRC number is 21 of 2023, and our office reference number is 198 of 2023. Chairperson, the one in respect of African law, the submitter, in fact, in the submission, preferred to be using the word African law, but we are appreciating perhaps in terms of what our Constitution is providing, the Constitution makes reference to customary law. Chairperson, the submission generally, CRC 4 of 21, the writer or the submitter made provision or a request that the recognition and development of African law must also be part of the review of the Constitution, where recognition is given and elevated of all the field within the African law. They further point out that it must also be academically given at the higher institutions or training institutions, and that is broadly the argument within the submission in respect of African law. The concern of the submission, Chairperson, it details what is appearing in Chapter 4 of the Constitution, which is basically setting out the powers of the Parliament. And then it speaks to Section 173, which is also my colleague that just presented did speak to in respect of the inherent powers of the Supreme Courts, as well as Section 39.2, because I think in respect of what was read for Section 39.2 is that it expressly includes common law, whereas the submission is saying that common law and customary law is included in the enactment and what is indicated or legislated in terms of Section 39.2, but the same is not appearing in respect of Section 173 when it is setting out the powers of the Supreme Courts of the land. Chairperson, as I indicate, Chapter 4 of the Constitution is the one that sets out the powers and the extent of Parliament as being the National Assembly as well as the National Council of Provinces, and has already alluded as to how legislation before Parliament must be processed when we are dealing with draft legislation. Chairperson, Section 173, as my other colleague read it, it actually speaks to the three courts, and that is why we are referring to them as the Supreme Courts or the High Courts of the land, the Constitutional Court, the Supreme Court of Appeal, and the High Courts of all the 9 provinces. And it speaks to the inherent powers that they are endowed with. This provision, it stipulates that the 3 Supreme Courts have powers inherent to them, where these courts must ensure that justice is protected and their processes are regulated. But mainly, as I said, the issue related to the submission is the development of the common law, taking into account the interest of justice. The submission is basically saying, why was the development of common law in Section 173 expressed and the development of customary law or African law as the term she preferred or he preferred, because I'm not sure, Chairperson, what the gender of the writer is. So it's indicated that the development of common law is expressed in Section 173 in respect of the inherent powers of the courts, but it does not appear to also say the same in respect of the customary law. In other words, it is our understanding that the submitter would have preferred the inclusion of customary law or what is called African law in this section, similarly as done in Section 39.2 of the Constitution as well. Now, Chairperson, because the provision that is referenced in my opinion has also been read for members, which is Section 39.2, I will not be going deeper into it as well or reading it again. But Chairperson, what basically that provision, it seems, and as has been explained as well in terms of the separation of powers principle, it deals with, in my appreciation, it deals with what the executive does when it's implementing and interpreting legislation, while on the par hand as well, it also addresses when the courts are also dealing with the interpretation when bringing justice and ensuring that the Bill of Rights, especially Section 34 of the Constitution, access to courts, is given effect. And that is why in the latter part of that same stipulation, it says that when interpreting any legislation and when developing the common law, and this is where I'm saying the problem with the writer comes through, customary law is there when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. Hence how I brought in reference to Section 34 of the Constitution. Then legislation that courts must interpret is developed and passed through stages, which my other colleague already explained. And just to add on, Section 85 sets out how then we go about in terms of initiating and developing legislation, as well as bringing it to Parliament if it has to happen at the executive stage, and then it comes through the processes of Chapter 4 that I reference in respect of the national legislature being Parliament in this instance. So this is where we understand the inclusion of Chapter 4 by the submission, Chairperson, that it's sort of sought to explain and bring how then the responsibilities and the powers of Parliament in respect of what they are asking, that the Section 173 provision should be looked into in respect of also having to ensure that the reference to customary law is done in that section when it's giving inherent powers to the courts. Moving further, Chairpersons. Generally then, the questions we thought the submission is looking into is why does Section 173 not stipulate similarly as does Section 39(2) by way of including expressly customary law, or the term used in the submission as African law? In other words, we are saying that in terms of Chapter 12 of the Constitution, that is the stipulation out of the constitutional legal framework that speaks to customary law, the recognition of customary law, as well as that the courts are enjoined to ensure that when dealing with disputes and issues that pertains to customary law, that customary law is in place, and it is also been recognized that customary law is not necessarily subsumed into common law, but it has a place of its own in our country, and that is why there is Chapter 12, and we also have judgments that are speaking into that issue to indicate that customary law is a law that stands on its own and does not necessarily has to be subsumed or become what we would understand as common law. Thus, in our understanding, as I was saying in this part, I am setting out the questions that are raised by the submitter. It is that perhaps the submission is saying, because under 173, customary law is not necessarily expressed, it is thus not recognized, whereas Chapter 12 is there to set out how it applies in terms of recognizing and how it must be applied when the courts are performing their functions in light of Section 173. We have, in our opinion, defined the understanding of what these terms could be, as well as then, in our view, is that if we comprehend what customary law, it is inclusive in respect of our own jurisprudence as well as legislation. It is inclusive of, because it is customs that are exercised by or followed by traditional or indigenous peoples. So it would, if you look at the existing legislation and the existing interpretations that has been given in terms of what customary law, it would be inclusive of what the writer is speaking to as African law. But perhaps then it's important on what the other honorable members had brought to indicate as we were listening, that perhaps we need to be clear on the African continent, as well as looking into our own jurisdictions or within our own continent to understand this. Perhaps it's a question that, if discussed and deliberated, as you would see in terms of our conclusion, whether African law is a better term as opposed to customary law, Chairperson. But I think what is also important then in terms of our response to the submission is that the structure of the Constitution and the way it was intentionally done by the Constitutional Assembly, as well as gone through the processes of certification by our apex court, the Constitutional Court, and for purposes of interpreting the provisions of the Constitution, there is an important principle there, especially when we have to interpret and understand the objects of the Constitution as well as the provisions of the Constitution. That is why the structure and the manner that the Constitution is crafted is very important also to understanding and to helping, because as a general sovereign legal framework of the country, even a layperson is supposed to understand and appreciate the constitutional supremacy and the space of the Constitution. Hence, in terms of Chapter 12, we do find that customary law is specifically recognized and spoken to. And under Chapter 12 of the Constitution, we have generally two most important provisions, which is Section 211 as well as Section 212. And in respect of Section 39, which, if we look at the title of Section 39 of the Constitution, it is also speaking to the same point that I'm raising, which is the point in respect of interpretation of the Bill of Rights. So what appears under Chapter 12 of the Constitution and what appears as well under Section 39 is the promotion of rights and ensuring that, including customary law, as we are in a pluralist state, customary law has its own place, and that is what I'm saying with the third bullet there, that the certification judgment, which my colleagues have pointed out, there were two of them that were done, as well as the Bay Alex Court judgments and many other judgments have spoken to the issue to ensure the place of customary law in our land, as well as ensure that the courts as well apply customary law accordingly and develop it accordingly, and ensure that in light of Section 34, it is used and cannot be disregarded. Then, Chairperson, moving on to concluding in respect of the opinion and the submission that they were seeking that the Constitutional Review Committee must look into the issue that under 173 the customary law is not clearly expressed. We do admit that perhaps as widely argued and written about, there is distortion of customary law, and there is a need as well to ensure that the distortion is attended to, and the writings have spoken to that. And we also see the active involvement of the courts as to how they are applying the living law and seeking to address the distortion of customary law that is taking place. And I'm saying this because the main point of the submission is in respect of Section 173, which are the inherent powers of the courts to develop common law. But in this instance, they are also saying customary law should enjoy the same. Customary law generally as bringing a point, which was to say they also needed to be taught, or anyone who's interested in understanding African law must be taught in our higher institutions of learning. We are aware that actually it is currently happening, and even for those of us who started studying during the constitutional and the Constitution framework coming into place, customary law is taught in most of the universities of this country. Furthermore, Chairperson, it is our view then, in light of the submission, that the Constitutional Assembly and the judgments of the country that our courts have given, and the way that customary law is being developed and how it's codified and used in terms of the legislation in place, that is a process that is on course and the development is going accordingly. However, we are then saying, should there be a need that the committee does anything in respect of this submission and policy changes are necessary, the issue of looking into the policy changes and any new white documents whatever related to the policies and in light of Section 85, even though Parliament can also initiate, but we are saying for policy purposes and engagement with all the stakeholders, it would be best placed at the domain of the executive, and the necessary collaborations or finding one another on what should go on, as well as the committee can perhaps also, if necessary, as a joint committee, see how it can perhaps bring the matter to the relevant portfolios that are dealing with the issues that are raised, because as we understand the structure of Parliament, and Parliament being the creature of statute as well. So it would greatly provide the space of engagement and collaboration and finding more views on how to go about on this issue. But in our conclusion, Chapter 12 of the Constitution and in the manner Section 39 is crafted to ensure that the courts are developing and improving customary law so that it is at all times subjected to the Constitution. We are saying that is on course, Chairperson. I don't know, Chairperson, that is the end in respect of submission 1, whether I should stop there and then can go on to submission 2 instead of dealing with them both at once. Thank you, Chair. I'll be guided.
Thank you very much. Let's see if there are any questions on that particular opinion. Okay, one.
Thank you, Chair. I just want to make my inputs by asking you, according to your own research, as this Constitution is our supreme law, does it fit for its own subject, or it's applicable for South Africans or abroad, based on your presentation? Thank you.
Any other questions? Dr. Slope?
Thank you. This is just a remark, not a question per se. I want to suggest that the reason why the Constitution is treating common law and African customary law differently is a historical one. Common law is the legal system of the country since colonization, and African customary law has never been allowed to develop. And it seems to me that's the reason why there is a clear distinction in the Constitution, and we will not, in my view, be able to solve that problem by making cosmetic changes to the Constitution. The problem is deeper than that. Judges cannot develop African law if they don't even understand it. So I don't think, quite frankly, making cosmetic Constitution should be the business of Parliament. That's just my view. Thank you, Chairperson.
Thank you. Any other inputs? Questions? Okay, could you try and answer the first question, please? It's a very broad question, and if you can't, I don't blame you.
Thank you, Chairperson, and thank you for that protection, because really it's a broad and very, very difficult question. I think I'll merely just make a comment that the Constitution seeks and tries to be as inclusive as it can, and that is maybe exactly where we are finding ourselves with all the problems that we are facing. And in agreement with Honorable Mr. Hlophe, Dr. Hlophe, we are actually seeing in some of the other judgments as to the difficulties and challenges that the judiciary is having in appreciating customary law as we know it and as it practiced, hence a serious place for engagement perhaps with what the submitter has indicated is necessary, but it's just the place and the domain where that engagement would take place. Thank you, Chair.
Thanks very much. Can we move on to the next one?
Thank you, Chair.
So this would be 198 of 2023 or CRC 21 of 2023?
Thank you, Chairperson. That is exactly correct. And this one is on the issue, again, as I said, they want or they seek that this committee must consider having expression of territorial waters as it's done in respect of the geographical areas. And what the submission coming from Dr. Denning, I would not want to butcher that surname, Chairperson, but that's why I have it there, as well as Mr. Ntola, who are arguing that Section 103 read with Schedule 1A of the Constitution should not only be speaking to provincial geographical areas, but it should be inclusive of the territorial waters as well. And generally, if we look at the opinion that we prepared, we are pointing out that perhaps I should just quickly, first, before I get to the legal framework, point out what they raised, which is that they assert that South Africa's constitution has no express or tacit provision for its territorial waters. They've also defined and follow the definition of territorial waters guided by the Maritime Zone Act, and they define it as a belt of seawater extending about 12 nautical miles, which is a definition, as I said, coming from the Maritime Zone Act of 1994. So they point out that Section 103 is only making reference to the 9 provinces, and it speaks to geographical areas, and the maps as already proclaimed or stipulated under Schedule 1A of the Constitution. In terms of our legal framework, we did point out that the term republic, as it appears in the Constitution, though not defined, but it is appreciated that it is inclusive of our territorial waters, and the definition, as I said, and as I premise the use of the other legislation while we're speaking to the Constitution, that the maritime zones and other legislation that is related to sea waters is crucial in terms of the issue that is being raised, as well as ensuring that we do not put too much details on the Constitution, because then it goes nicely and perfectly with the processes that are set out in Chapter 4, as well as processes that are required to involve provinces, that we deal with the matter better through legislation and more details and consultation in terms of the national legislation. That said, Chairperson, we are also making reference to the conventions, the international conventions, and some that deal with these issues are the one on sea waters and maritime conventions, which we are also indicating that South Africa is already a signatory to, and most of them have been domesticated as law in our own country and are enforceable through those relevant legislation in place. And as we point out there, the department or the portfolio of transport is also the department and ministry in our country which is looking into the issues, and as ministerially required, that they deal with all the matters of international law and making them domesticated into our country. The United Convention on the Law of the Sea dictates for the peaceful use and passage of the sea, and therefore our argument is that if we go further to Section 21.3, which is under the Bill of Rights, which enables that and gives a right that we all have a free movement wherever in the Republic, and that is also an issue, as I said, and explaining the context of Section 39 is to be addressed, and we believe that the manner the Constitution expressly only speaking to the issue of geographical areas as opposed to including territorial waters is exactly to deal with the concerns that may be in terms of the international arena, since the sea must have open passage, and the international conventions are addressing those issues. Then what we are pointing out furthermore, Chairperson, is that in terms of Section 39 and how international law in terms of Chapter 14 is addressed, it will also seek to ensure that there is proper involvement and consultation of all those that are concerned, as well as the international states, because international waters and sea waters, as I said, it's territorial waters that should be opened internationally. But then when it comes to our ports and harbors, we believe that the legislation, and as it being developed now and again with oversight that that is conducted over the executive, as well as the public participation when legislation is being processed as a draft, that is the place that also, in terms of staying within our state as a sovereign state, it's being done, and with the processes under Chapter 14 and how the Constitution dictates the way we play in the international arena is also crucial. Therefore, we are of the view that the guidance that comes within Chapter 14 and Section 39 in respect of international law and the issues that are raised is not necessarily a place that should be expressed in the Constitution. Should be expressed in the Constitution. But I think it's sufficient in terms of how it's done, and the constitutional framework that is in place is also, it suffices to cover the issues and the plethora of laws that are progressively coming before Parliament, and the way it's done. It speaks to the interface and the issues that are involving other sovereign states, as well as ensuring that South Africa is a sovereign and constitutional democratic state on its own. It engages with its own people and also ensures that whatever is then to be domesticated as our law and passed at the international arena, our own people are involved and are aware of what is happening and how it impacts on them. It is thus our view, Chairperson, that in respect of this being an issue of international states and international law, it may be unwise to tamper with the Constitution in the manner that it's drafted. And as we look at the current international occurrences, then and the negotiations that are still taking place, rather we protect the Constitution and make sure that it is implemented correctly and understood correctly, but it is also open to the committee to decide if it's really necessary to include territorial waters as part of defining our republic in terms of Section 103 of the Constitution, which was merely speaking to the 9 provinces that the country has. Thank you, Chair. That is where I end with the submission on territorial waters. I don't think I did mention where it also comes from. The submitter in respect thereof, Chairperson. I'm just quickly trying to find the writers. Oh, I did. It's Dr. Metuge as well as Mr. Ntola, Chairperson. I thank you.
Thanks. So in retrospect, you decided to butcher the surname. Any questions on the submission from any members? No. Okay.
Thank you, Chairperson. For the sins of the committee, Chair, I'm also presenting 2 opinions, so you're going to have to, unfortunately, listen to me for a little bit longer than you may have liked. Chair, I'm going to start with CRC 10 of 2021, and this is a submission received from the Kara Heritage Institute requesting that Kiswahili be made an official language. The Kara Institute is a non-profit organization, and it seeks, amongst other things, to promote African languages. So Kiswahili, or Swahili, as most people would know it, is an East African lingua franca, meaning that it's a language used between people who don't speak one another's native language. It's an official language of the African Union, as well as a national language in various African countries, including Kenya, Rwanda, Uganda, and Tanzania. And UNESCO has noted that it's amongst the 10 most widely spoken languages in the world, currently with over 200 million speakers. There's also evidence that the language is growing and spreading to southern, western, and northern Africa. And because it is a language of trade and inter-ethnic communication, there is an argument to be made that it is a means of improving and increasing trade, and also a means of possibly promoting greater social cohesion amongst Africans on the continent. In this regard, it has been referred to chairs as a powerful agent of integration and a means of building Ubuntu between Africans. That all came from our own research. The Kara Heritage noted other motivations. According to them, Kiswahili is one of the official languages of the Pan-African Parliament. SADC heads of state during a meeting in Tanzania agreed to promote the recognition and teaching of Kiswahili in their countries. The universities of Zimbabwe and Namibia are already teaching Kiswahili, and the South African government has already agreed to introduce it in South African schools. In fact, since this opinion was written, it now has been introduced as a second additional language, with Minister Angie Mosheka, the previous Minister of Education, saying that the introduction was aimed at contributing to decolonization. Lastly, the Kara Institute argues that the recognition as one of the official languages will assist South Africa in promoting Pan-Africanism and African cultural renaissance. The legal framework, as members know, we have a progressive constitution, and it's certainly so in respect of language rights. The constitution contains a multiplicity of language and language-related rights. These include, in the main, Section 6.1, which recognizes now 12 official languages. The last, most recent edition, or the only edition since the adoption of the Constitution, being sign language. Section 6.2, which creates a duty on the state to take practical and positive measures to elevate the status and advance the use of the 9 indigenous languages that are mentioned in Section 6.1. And then Section 6.5, which establishes the Pan-South African Language Board. And that language board is tasked with promoting and creating conditions for the development of all official languages, and promoting and creating conditions for the development of the Khoi, Nama, and San languages. And in fact, this committee will see that it will often receive submissions in respect of those languages in particular. And then it must also ensure respect for all languages commonly used in South Africa, including any languages used for religious purposes. Section 9.3 then provides that no person may be unfairly discriminated against on the basis of their language, and that would include whether their language is an official language or not. And Section 29.2 provides that every person has the right to receive education in the official language or language of their choice in public educational institutions where it is reasonably practical. Sections 30 and 31.1 afford a person or community the right to use a language of choice, and Section 35.3k affords an accused person the right to be tried in a language of their understanding, or if not practical, to have the proceedings interpreted in that language. The Constitution then also provides in Section 6.3a that national and provincial government must use at least 2 official languages for the purposes of government, taking into account usage, practicality, expense, regional circumstances rather, and the balance of the needs and preferences of the population as a whole, or the population of that province. And then in contrast, local government requires that municipalities must take into account the language, usage, and preferences of its residents. Official languages are also then further regulated in terms of other legislation. There is the Use of Official Languages Act of 2012, which provides that national and provincial departments must adopt a language policy which indicates the official languages that they will use for government business. Chairs, there is research to indicate that there are no immediate or practical consequences that flow from the mere declaration of a language as an official language. Rather, legal content is given to official language policy through the regulation of state action relating to the use of languages in courts, the use by the legislature, or the use of language for other official government purposes. But I don't think that that statement is entirely accurate in terms of the South African context, because our constitution, the supreme law itself, regulates language. And it requires that our national and provincial government conducts its business in 2 or more official languages. Therefore, we already deal with some of these issues in terms of regulation of language in the Constitution itself. Notwithstanding that the designation of a language as an official language has definitive consequences in as far as it's elevated in terms of the national provincial sphere, it is important to note that our Bill of Rights refers to language rights in a general sense, rather than referring to official languages, which I had said previously by way of example, an accused has the right to be tried in a language that they understand, or at least to have the proceedings translated. For purposes of government business, local government also may choose any language, irrespective of whether that language is an official language or not, subject to the use and preference within a particular municipality. So it is clear that the Constitution protects the rights of the users of official languages as well as non-official languages. However, that extent of that protection obviously differs. It's important to note that the Language Board, in terms of the Constitution, must promote and create conditions for the specific development and use of official languages, and then also the Khoi, Nama, and San languages. In contrast, they must only promote and respect other languages commonly used. So they don't need to create conditions for the development of other languages, but rather ensure that people are not discriminated against for the use of other official languages. Then in addition, there's also legislation that may afford more rights to official languages. For example, the Broadcasting Act refers to programming that must be done in official languages. So there's nothing that would, for example, compel the SABC to have programs in any other language other than official languages, even though we know that they frequently do broadcast programs that come from non-official languages. So the recognition of language as an official language obviously creates certain positive obligations on the state, and those are generally geared towards preserving and promoting the language and also allowing the speakers to access state resources and information. In the case of Swahili, it's not an indigenous South African language, so it is an interesting matter because the issue of discrimination on the basis of language, therefore, is obviously not something that would come into play in this example. Also, the designation would not be linked to protecting any specific cultural or religious group, as may be the case, for example, with Kilovedu language, which this committee has received a number of submissions in the past, which is a language that's predominantly spoken in Limpopo, and those communities have asked for that to be given official status. So it appears that the recognition is sought rather on the basis of elevating the language for international rather than national interests. During the certification of the Constitution in the first certification judgment, the court did not set out any criteria that must be used for the determination of a language as an official language. Constitutional Principle 11 simply required the protection of language diversity, so it was kept rather broad. And it's interesting, for example, there was an objection that Indian languages were not included as official languages, and the court noted that this was a policy matter and it would not render the Constitution as it was drafted then unconstitutional. So in determining whether Swahili should be afforded official status, it's therefore submitted that instead of the ordinary considerations that the committee would consider, such as preserving language, the right of minority groups, ensuring speakers have access, that they understand a language in order to access government services, there are other matters that the committee would have to look at. This includes the willingness of ordinary South Africans amongst us to embrace a language that may be foreign to them, and I say that in inverted commas, given that it's not an indigenous language of South Africa. Then whether there are in fact economic advantages that may attach to designating Swahili as an official language, and whether it will promote trade and business relations amongst South Africa and other African countries. Whether the designation of Kiswahili may result in less resources being made available for the development and protection of other indigenous official languages, because the moment this is declared as an official language, it does mean that resources would have to follow. And then the availability of those resources to practically promote the language, because official recognition alone is unlikely to have a major impact in the absence of a dedicated policy to promote the language. And then lastly, the value of designating it as an official language as a means of improving social cohesion on the continent, and particularly tackling the issue of xenophobia, which we know is a challenging issue in the country at the moment. The above considerations must also be weighted against the question of whether official status is in fact necessary. As I've indicated, the government has already committed to promoting the Swahili language, and they've taken positive steps in this regard by already including it as part of the curriculum. It is also taught at tertiary level. So the committee has 4 things that it can do going forward, bearing in mind that this is a policy matter. The first is not to include it as an official language and allow the status quo to remain. The second is to amend Section 6.1 and include this as a 13th additional official language. The third is to amend Section 5A of the Constitution, and that way compel the Language Board to promote and create conditions for the development of Swahili. If the committee is going to consider that, then I would like to add my own submission, if I may, that the committee also considers other indigenous languages that have been left behind. And then lastly, to consider whether there is a need for Parliament to investigate perhaps amending any existing legislation dealing with language, or introducing new legislation aimed at directing language policy in order to promote non-official languages. So that wouldn't entail any constitutional amendment. Given that the recognition of Swahili differs from the recognition of other indigenous languages, because as I've explained, its benefits are mainly outward looking, it would be desirable for the committee to further engage with CARA and other proponents of the language to explain what benefit they seek to achieve through the recognition, and whether these benefits cannot be achieved through other means. The committee must also engage with the broad public and be sensitive to the views of ordinary South Africans, some of whom have been calling for the recognition of their indigenous languages for many, many years. At the same time, balancing that against the practical impact of the recognition of the language and how this may advance economic interests. Thank you, Chair. That brings me to the end of the first presentation.
Thank you very much. Any questions on this presentation?
Yes, Chair. Can I just understand how, do we have an idea of how many people speak this language in South Africa? Thank you.
Chairs, through you, I was unable to find that factual information when I did the opinion, but I can go and have a look. These opinions were done quite some time ago to see if there's any updated information. Thank you.
Mr. Navola?
Yeah, thank you, Chair. No, I just want to find out what adverse impact occurs when the language is not recognized. From a legal perspective, what is the adverse impact? But subsequently, Have you done a research of how many indigenous languages are not recognized? And are we supposed to consider the sign language as an indigenous language, the sign language? I'm just asking a peripheral question. Thank you.
Thank you, Chair. Chair, sign language has been now included as an official language, and the impact of being an official language as opposed to a language that is not recognized as an official language is that only official languages can be language of government and language of the provincial and national government, which is why I've said that this particular one is an interesting one because it's not dealing with an indigenous language. So one cannot argue that speakers of this language won't have access to government information and resources by virtue of language alone, because people that speak this language are speaking it as a lingua franca. It's only because they cannot, they don't share a common language with other speakers. So it is unique, and I think it should be treated, therefore, differently to the way we would treat our local indigenous languages. As I've said, the committee will routinely receive submissions on other indigenous languages. The problem has always been that it comes down to resources, because once a language is determined to be an official language, it does mean that there has to be a greater resource allocation, because the state is then liable to positively promote the development of that language. Chairs. Thank you.
Thank you. Members, when we deliberate on this and on the others, we will also deliberate on those which, in our view, we need to have more public participation on or oral presentations on. So we'll be able to deal with those issues at the next session. Thank you.
Thank you, Chairperson. Moving on to the second opinion. It is an opinion from CASIC, which is the Council for the Advancement of the South African Constitution.
What's the reference number, please?
The reference is CRC 8 of 2021. And this is a proposal to change the structure of Chapter 9 of the Constitution. So as most members may be familiar, CASIC is a non-profit public benefit organization which seeks to advance the South African Constitution as a platform for democratic politics and the transformation of society. And what they've proposed is to fundamentally alter the structure of Chapter 9 of the Constitution, and that's the chapter that deals with it's the chapter that deals with the Human Rights Commission, the Commission for Gender Equality, the Commission for Promotion and Protection of Rights of Cultural, Religious and Linguistic Communities, and then also has the Public Protector and the Auditor General. The submission is not calling for the merger of the Public Protector and the Auditor General, but only of the ones I've mentioned, and in addition to that, to also include in there the Pan-South African Language Board, which is not covered in Chapter 9 currently, and then also the National Youth Development Agency, which is a creature of statute. In support of their submission, CASIC places reliance on the 2007 ASMAL report. And this report was a report done by Parliament in terms of these Chapter 9 institutions to consider the effectiveness and the efficiency of these institutions. And that report, Chairs, which I can share with the committee, it is linked, in my opinion, recommended, amongst other things, the establishment of a single human rights body named the South African Commission on Human Rights and Equality. And it was recommended that this body consist of all the institutions that I previously mentioned. So it was in favor of this amalgamation that CASIC has now submitted. To date, the NA has not taken any concrete steps to implement the recommendations contained in the ASMAL report. This was just one of the recommendations. There were several. And the ASMAL report based its recommendation on the following. One, that there was an uneven spread of resources and capacities in respect of these Chapter 9 institutions, which in turn obviously affects the efficiency and effectiveness. Some were better resourced than others. Then they found that the current constitutional arrangement causes fragmentation and results in a duplication of approaches to the application of the Bill of Rights, which the committee found to be undesirable. So, for example, you have a gender commission dealing with gender rights, but you also have a human rights commission, and arguably gender rights is part and parcel of human rights. They felt that a single human rights body would minimize the risk of duplication of roles due to the overlap in the mandate of these institutions, and then it would also obviously then optimize the use and allocation of financial resources and improve administrative efficiency. They felt that it would be more accessible to the public as a sort of a one-stop shop for the lodging and processing of complaints, and ensure an integrated and interdependent approach to addressing human rights violations, as opposed to the public being chased from pillar to post when they're trying to complain about a human right violation. Firstly, it's important for the committee to understand what the purpose of these Chapter 9 institutions are. My colleague, Advocate Jenkins, explained in some detail about the doctrine of separation of powers and accountability, and the Chapter 9 constitutions have been established precisely for that purpose. It's to support democracy, they're independent, they're impartial, and their main purpose is holding government accountable and ensuring that organs of state adhere to the Constitution. There are, as I indicated, 6 Chapter 9 institutions, 2 of which are not subject of this particular submission, being the Public Protector and the Auditor General. And Section 181 of the Constitution says that these institutions must be independent and they're subject only to the Constitution and the law. They must be impartial and they must exercise their powers and perform their functions without fear, favour or prejudice. And then, of course, we know that other organs of state must assist and protect these institutions. During the first certification judgment, the Constitutional Court held that the constitutional principles do not require the establishment of 3 of the proposed institutions in Chapter 9. And at the time of the interim constitution, there were only 5 institutions that were included in Chapter 9. And the court found that the only ones that were necessary in terms of the constitutional principles were the Public Protector and the Auditor General. Therefore, the decision to include the others is purely a policy decision. Even if the Constitution were not to have the balance of the Chapter 9 institutions as we know it, there would be nothing unlawful about that. So clearly the establishment of these institutions, the structure, the format in which they operate is a policy matter. So the simple answer to the submission from CASAC as to whether the committee can do this is yes. And Chairs, whilst my role is not to advise on policy, I have compiled a list of matters that the committee can take into consideration when discussing and deliberating on the desirability of amending the Constitution for purposes of streamlining these institutions. And this includes, firstly, the fact that the Asmal report is now just shy of 18 years, I think. And so the landscape may or may not have changed as regards matters relating to financial allocation, resources, government governance arrangements, and the relationships between these institutions and Parliament. So we're not in a position to advise to what extent the practicalities that inform that Asmal report still hold true 18 years later. So there definitely needs to be some investigation into that. Then Chapter 9 institutions play an important role in protecting and promoting the Bill of Rights. There's general agreement that they play a vital watchdog role. And the question is whether this role is better fulfilled by means of streamlining it into one umbrella body, or if different bodies are better placed by focusing exclusively and specifically on different areas. Then regard should also be had as to whether the establishment will result, in fact, in cost savings. In this regard, the committee would have to look at both short-term and long-term cost implications. What would be the practical effect of dissolving these institutions? How do you deal with moving of staff, and so on? And then to check whether there is in fact a current duplication of work between those institutions which limit their effectiveness. And the committee must then also have a robust debate on whether oversight and accountability, which is our primary role here in Parliament, will be strengthened if an umbrella body reports to Parliament as opposed to the fractured way in which it's done now. So at the moment, each of these institutions report to different portfolio committees, and the question is whether there should be an umbrella body perhaps reporting to a specific committee of the NA. And then lastly, whether such a merger is going to benefit ordinary South Africans. And in this regard specifically, will access be strengthened by them having one contact point, and will money be saved? The above considerations must be weighed against the legal consequences, as I've said, that will flow from a restructuring. It will require that various pieces of legislation is amended to create for the practical effects of dissolution, and that there will have to be a new standalone act to cater for this new umbrella body. CASAC does deal with some of those practical implications in the submission, Chair. So while it is a policy matter, it is one that certainly carries with it a number of legal and financial consequences that the committee would have to factor in. So the choices available to the committee is either not to support the call for this amalgamation and to allow the status quo to remain. Secondly, to amend Chapter 9 to provide for a single human rights body as proposed by CASAC and in accordance with the ASMAR report. The third is perhaps to propose an amendment or restructuring of Chapter 9, but in a format that differs to the one that CASAC and the ASMAR report has put forward. In other words, perhaps to merge some of these institutions and not others. And lastly, to consider whether, in fact, that is necessary at all, or if some of the practical problems that the ASMAR report pointed out could, in fact, be fixed by amending existing legislation in a bid to strengthen these institutions through either increased budgetary allocations or powers. So the key question before the committee really is one of efficiency and effectiveness. But any meaningful answer, however, requires the committee to further engage in some detail with the factual positions that these institutions find themselves in today. And the committee is therefore advised to engage internally in Parliament with the Office of Supporting of the Institute Supporting Democracy, which is an internal office here in Parliament, the Chapter 9 institutions themselves, the public, and then, of course, civil society, because it is a matter that has garnered quite a bit of attention in recent years. Thank you, Chair.
Thank you very much. Any questions on the submission? Okay, thanks. We can, Mr. Gericke?
Yeah, but constitutional matters this. I don't know if somebody is present here that has knowledge of the attempt of the Human Rights Commission that tried to include the Judicial Inspectorate of Correctional Services into their framework. I know a year or two ago there was such an initiative or an attempt, and there was a legal opinion that nullified on various grounds. I don't know. I'm just asking, Chair, if there's somebody, if we can have that opinion. I don't have that opinion, but I know that matter has been ruled out due to various considerations. Maybe that opinion will assist us if we have going forward. Thank you.
Thank you. If there is such an opinion, could it be circulated to members, please?
Thank you, Chair. Thank you, Chair, for in the very same presentation. I wanted you to find out that what is your take on the issue which you raised about the issue of ASMAL report and the recommendations. Have you interrogated it? Have you maybe done some of the research that what is it about exactly? Thank you.
Chair, on the first matter, we'll certainly go and look if we have an opinion. I'm not aware of an opinion from our office. It may be an external opinion, but we'll try and do some research to locate any information on that matter. On the second one, Chair, I have looked quite closely at that ASMAR report, not just for purposes of this opinion, but for various other matters that I've dealt with in Parliament. My gut instinct, Chairs, is that report probably still stands, even though it's 18 years later, that the situation may in fact be far worse than what the report set out. There has been various issues facing these institutions, and besides the effectiveness of the institutions is also the issue of the amount of resources that are being ploughed into it, and whether those are justified, and at the end of the day, what can be done to improve access for citizens so that these institutions actually do what constitutionally they meant to do, which is to hold government to account. So there are various things that would need to be considered, and my own submission is that over and beyond the consideration of the merger, there's actually even more important things to consider. Whether the law as it currently stands truly allows for these institutions to be independent, and what it is that are the challenges that are being faced by them in ensuring that they're able to hold government to account. So I think the question is much bigger than what CASIC has proposed, which I do think the committee should look at, and it's going to require almost a side project on its own. I don't think it's something that can be resolved in just a matter of a few public submissions, Chair. Thank you.
Thank you very much. My own 2 cents worth is that all members should read very carefully the ASMAR report. And if you have not yet read it, it makes wonderful bedtime reading. Guaranteed you'll never sleep again.
Thank you, Honourable Chairpersons. I was waiting for last, hoping that I'm going to get some messages from my colleagues that are not here, that they will come and save me. The next one is again from my colleague Andile Techane, and it deals with a submission from the Helen Suzman Foundation, which it's not a large or a huge submission. It just focuses on 2 areas of the Constitution, Section 174 and 178. But
What is the reference?
The reference number is 196/2023. The submission itself again, first it goes to Section 174 regarding the appointment of judges. And there it suggests almost like an empowering clause that should be put in there to allow the Judicial Service Commission to make additional and to publish those additional qualifications that's required for the appointment of a judge. So the submission from HSF, Helen Suzman Foundation, is that there's too little, too sparse requirements when it comes to the appointment of judges, and we need to build that out, and the Judicial Service Commission should have the power to put that out there and to publish it, of course, with public hearings, one can assume. That's the first part of the submission, Chairperson. The second part of the submission deals directly with the Judicial Service Commission, and the submission says that the 3 persons identified, the people identified by the National Assembly and the persons identified by the National Council of Provinces, and then there's a president that can appoint more people, makes the Judicial Service Commission a little bit politically heavy on the one side and not enough technocrats, I assume, on the other side. So that is a policy matter to decide whether we agree or don't agree as Parliament with the way the Constitution sets out the membership to the JSC. The opinion again looked at the constitutional principles. The Constitutional Court didn't find anything. In fact, there were no submissions around the appointment of judges. There was a submission around the appointment of acting judges, because that was the Minister of Justice and Constitutional Development then, but now Correctional Services. His or her purview to appoint acting judges, of course, on the recommendation of the Judge President of the specific division. So the Constitutional Court found that that is not a transgression of the separation of powers. There's nothing wrong with the executive appointing that. So in short, that is the submission, Chair. Our advice on this is, of course, it's a policy matter to see whether the composition of the JSC is correct. And insofar as the JSC can put additional comments there, Chair, again, it's a policy matter. I've listened to some of the interviews there. I think the JSC, I mean, they've got a lot of discretion. And the questions they ask and where they're going, a lot of the time reflects sort of an ideological position that part of the Judicial Service Commission has. And yeah, Chair, from a legal perspective, there's nothing wrong with that. Whether somebody likes it or not is a different matter. But legally, we don't find anything wrong with the, as it's operating, and neither the Constitutional Court in the certification judgment, ma'am. Thank you.
Thank you. Any inputs on that? Any questions on that legal opinion? Okay, nothing. We'll deliberate.
Yeah, Chair, I think the presentation on this one was very slim. I was expecting more details. But nonetheless, Chair, with regards to Section 165, I think it places the judicial authority to the Chief Justice, who must be in charge with the running of the judicial. Now, where it becomes problematic is when the magistrate courts are placed under the Department of Justice, when the executive is supervising the work of the lower courts, the district, regional, and the small claims court. Now, is that not in conflict with Section 165? And on top of that, when we deal with this on deliberations, are we going to have a leeway of going beyond what has been proposed by people who submitted this, the Helen Suzman Foundation? Can we go beyond what they desire us to do? Thank you very much.
Honourable Member, if I may answer the second question first. The Constitution requires for Parliament to have rules for a joint constitutional review committee that must review the Constitution annually. So for me, that answers your question. This committee decides what it wants to review. What we are busy with now is we are busy with the public participation process. We are presenting the legal aspects of what came from the public, but I don't see anything preventing this committee from bringing their own issues into the Constitution review process. And to, if there's agreement, of course, to submit a report to the House and see what happens there. And in that process, request further public submissions on your own ideas or own concepts for the change. The issue of the magistrates' courts under the Department of Justice, it was not part of the submission, so I'm going to embarrass myself if I give an opinion on that. I'm not sure if that has served before any court or whether there, and what level of supervision is over the magistrates' court. But as far as I know, magistrates' court is part of the judiciary. And as such, it needs to be independent. And the separation of powers applies 100% there. There's a difference if you're looking at CCMA. Those are administrative tribunals. And one can say that belongs or fits nicely, and there can be proper supervision from the Department of Justice. It's an alternative dispute resolution. But magistrates' court are courts, as far as I know. But I don't know the details of that, so I'd rather not embarrass myself. Thank you.
Okay, thanks very much. Mr. Numvala, I'll get to you, Mr. Gericke. Mr. Numvala, the magistrates' court, in fact, form part of the judiciary. Not really. They just assisted with the Magistrates Commission there, but they have a similar process. But we can deliberate on it. It's fine. Mr. Gericke?
Chair, just maybe a question on what the sir has said now. The colleague has said now. If we receive this, for instance, this is a submission, and I shall take it that the submission by, for instance, this Helen Suzman Foundation will serve as the terms of reference for this specific item, so to speak. It's a mere matter of semantics here, but the terms of reference. So if we say, for instance, what you have said now, sir, that the Commission is able to entertain this, to deliberate on this, to disseminate and so on, but we can also bring in our own legislation or submissions and so on. I'm just worried about the fact that we will lax the rules or relax the rules in order to temper or to add on to what these organizations submit. In other words, what I'm saying is we should not leave room to go and change something that is not asked to be changed, so to speak. This is what I'm asking, or asked to be amended. Unless there's a request for amendment, I don't think the committee will have the power to scratch there or to interfere there unless the request is explicitly asking so. Thank you.
Mr. Gericke, the joint rules are clear. If you don't have a copy of them, I can ask that you get a copy, please. But the joint rules are clear. This committee has, it's within its ambit to consider any amendment, including amendments that this committee think should be considered. And so we're not limited to submissions and requests. And when we look at these, of course, we will, when we deliberate, we will look at the desirability of other issues. And if an issue needs to be moved by the committee, then, and there's sufficient consensus in the committee to move it, then we're at liberty to do so.
Yeah, no, I do understand what you say, Chairperson. The fact of the matter is we need to understand the context. You don't want to interfere in an area or on a terrain where you are not asked to interfere. This is merely, we can debate that going forward, but if the Helen Suzman Foundation asks for specific intervention in respect of certain issues, then I think we must take into consideration the initial submission. And I don't say we must undermine the rules, but we must understand the context of the rules. Thank you.
Thank you, Honourable Chairperson. We are now going to just the last two. I'm going to do 192/2023 first. That is your reference 5/2021, 5 of 2021. Submission from Activate Change Drivers that proposes an amendment specifically to section 152(1)(e) of the Constitution that deals with local government, the objects of local government, and that specific one is to, I think it's to encourage public participation. The submission is built around the aspect of public participation and literacy of the Constitution. And the submission actually indicates that there is a lack of understanding within South Africa of the Constitution, and it makes it difficult for people then to make submissions on the Constitution. And it asks Parliament, when considering the submission, to look at ways in which that can be compulsory, to have more public education of the Constitution and how to make these submissions. And then specifically with regard to section 152, rather to say, I think it says encourage, to say it must, to make it a peremptory provision. Now, our response or our analysis of that is, if we look at the opinion, is to, there's various provisions in the Constitution that we've dealt with. Section 59(1) is one of them. I think 71 in terms of the NCOP and 116 in terms of provincial legislatures. All of these require that there's public participation within your legislative processes. The opinion then goes forward and lists, first it looks at the rules, but I think for the purpose of this committee, we can focus on the Constitution and legislation, as well as court cases. So the opinion indicates that we have what is written in the Constitution, and in Doctors for Life, the Constitutional Court said it's in fact a peremptory step in the legislative process to have public hearings, and not public hearings, but public participation. To facilitate public involvement is what the Constitution requires. And the Constitutional Court, in various judgments that are listed in the opinion, have given meaning to this phrase in the Constitution, to facilitate public involvement. And it necessitates creation of a reasonable opportunity for public to make a meaningful input into what is happening before that legislature, whether it's legislation or whether it's another matter, like, for instance, what we are busy with here. And there were further court cases that dealt with issues, specific problems about translations, about public hearings that were not advertised beforehand, translations in languages of the local population that weren't available on the day when the people wanted to deal with this. And the courts have made various findings in this regard. Findings that the legislature, whether it's the NA, NCOP, or provincial legislature, is required to do public education, to educate the people, in other words, to empower them to make a submission, as well as then to have those hearings or written submissions, and to give a proper opportunity for that hearing, and then to be open to change. It can't just be a tick-box exercise. So, in effect, what we are saying in this opinion is to say the courts have pronounced on the issue of public participation in quite detail. And it's not really necessary to put further detail in the Constitution. I'm not going to say or legislation, because we are having an area of we don't know how. If I may take the committee into this, we're busy at the moment with a challenge to the Public Procurement Act, in which we've sat through various public hearings, as well as extension of public hearings, as well as to require, again I said we, but the chairperson, requiring the National Treasury to negotiate further with the people making submissions on new clauses, and then to bring it back to the committee, analyze it and work through it. Yet this bill had to be passed before the elections for obvious reasons, because we didn't want it to lapse and have to do everything again. But this matter has been taken to court on public participation at the moment. So one must realize that there is a little bit of uncertainty always hanging, and it's not impossible, and it's also not a bad idea to actually have an act at one stage setting out how public participation must be done. And if this act can be eventually challenged, but found to be constitutional, then we know exactly what the rule book is required, or what the framework for public participation is. At the moment we are having a lot of court judgments, and Parliament itself has its own public participation unit to assist with doing this constitutional requirement. So, in short, our view is that we don't need to change the Constitution to ensure public participation. It's already there. The second question are around the local government. Chairperson, that one, in my view, is covered by those court judgments, and we have in the Municipal Finance Management Act, in the Local Government Structures Act, I think it is, that deals with the integrated development plans of local government. As far as I know, there are lots of, not lots, but there are provisions that require public participation at the critical areas in approving that integrated development plan, in dealing with finances of municipalities, in dealing with tenders of municipalities. So at local government level, there is quite a number of concrete steps taken to actually legislate for public participation. So we feel, we don't really feel it's necessary to go in further into this, Chairperson. Chair, I just wanted to see, I'm not sure if it's this one or my last opinion that deals with the effect of the recommendations from the Human Rights Commission. I think it's the next one. So I'll deal with the next one, yeah. So that's it, Honourable Chair.
Thank you. Are there any questions on this? Mr. Giereke?
Chairperson, yes, I agree with the sir that public participation is a critical element of our constitutional democracy. I think we must go much deeper as a committee in this. I take cognizance of the fact that the gentleman is saying that we should not change or amend the constitution. I don't want to go deeper in as per your warning, but you must understand the issue on local government level is a different issue than what you have on national level, for instance. They will public participate with only a certain group of people, then they will say we have participated with everybody. They will pick the ratepayers and they will pick whatever, and they will say we have passed scrutiny in terms of public participation. I think there's much deeper to go in here. It's my submission. Thank you, Chair.
Thanks, Mr. Gericke. We'll certainly do that when we deliberate.
Before I get my apologies, Honourable Chairpersons, that submission we've just dealt with actually does mention that it's a problem that the recommendations of the Human Rights Commission and other Chapter 9 bodies do not carry enforcement value. Now, that matter is presently before the Constitutional Court. The High Court as well as the Supreme Court of Appeal have found that other than with the Public Protector, the recommendations of the South African Human Rights Commission is not binding. And there's 2 judgments on that, in fact. Chairperson, the last one is on, it has 2 areas. It's a submission from Ms. Lungiswa Ngwenye, NGU. I'm butchering that one, Chairperson, but my surname also gets butchered. So it's Ms. Lungwisa Nguye, and okay, now I'm going to leave it. Thanks. And it looks at almost the efficiency of cabinet, Chairperson. So firstly, it looks at section 91.3, and the reference number is 193/2023 of our office, from the Constitutional Review Committee, number 6 of 2021. Now, in respect of section 91.3, it deals with the, if I'm not mistaken, the appointment of the cabinet and allows the president to elect 2 persons outside of the National Assembly to be part of cabinet. The submission is that this is insufficient because there are much talent out there, people who understand government better than the members of the National Assembly that should be able to come into Parliament. Now, Chair, I'm going to get back to that. I'm smiling because it deals also with the appointment of judges. It's in fact what we're seeing in America, and when I was studying my way back, we spoke about the anti-democratic premium of the judicial authority. And how do you make sure that the people who are at the judicial authority, which are not elected, understands the people? And South Africa has its own method, and other countries have its own methods to bring that in, whether it's approval by Parliament or whether some other way to control it if there are complaints against the judicial officers. But we're speaking of cabinet here, and as we've seen in America, some of the cabinet members there must be confirmed by Congress, and others can be appointed, although they're not elected. South Africa has dealt with that issue of the sort of anti-democratic election of cabinet by saying there's only 2 members of cabinet that comes outside. So I personally feel that our system is more democratic, but nothing stops us from changing it. It's democratic because people have elected the members of the National Assembly, and the president is elected by the National Assembly, and the president must choose members of the National Assembly to be in cabinet except for the 2. So your vote counts, in other words, right up to the top and who votes for who. But there are different systems in the world, but that's the first part of the submission. The second part of that first part of the submission is then the role of Section 93, the role of deputy ministers, which the submission considers unnecessary and expensive, and we should do away with that. Now, the deputy ministers play a specific role. They get specific delegations in writing in terms of the Constitution from the ministers. And there's some departments that have grown that there are 2 deputy ministers there. Now, this again is a policy matter. It's how the president and the executive does their work, and I don't think it can just be removed by a slice of a pen without seeing how it will affect what is happening in the ministries and in government. But Chair, that's the first part of the submission, dealing with ministers and deputy ministers. The second part is dealing again with the separation of powers, the Section 217. It's the appointment of the Commissioner of the Police Service, which is again in the hands of the President. And I think we've said said something about that, whether that's desirable or not, whether there should be more qualifications given for such a person, or whether there's more checks and balances that should be put in there. That is the debate that the committee can have on that matter. In our view, Chairperson, in our view, what we're hearing, what I'm seeing in the various submissions, and one almost picks up a trend then, is that since the President has appointed the present, I think she's nearing her term, I've said it already, the National Director of Public Prosecutions through a public participation process and through panels, almost through a technocratical process. There's more and more people who think that that's a good process, and we should actually try and put that into law, preferably constitution according to the submissions, but one can choose another law because it might not be so difficult to do it in that. And now this is also now going to the National Commissioner of Police. The submission is saying we should have the similar situation with the National Commissioner of Police. And it can't just be left to the President on his own. That's a policy matter for this committee to deliberate. Thank you, ma'am. That is the 10 opinions we had to do. Thank you.
Thank you very much. Any questions on this submission? Okay. Thank you very much to the legal division. This is a huge amount of work and very competently presented, so thank you all. Lots of preparation for the committee members for the next meeting. We'll discuss that in a moment. And we will try and get the documents requested to everybody in time. And I think we should accept that the next meeting will be quite a long one. I'm not sure that we'll get through all of these reports in one meeting. It may take quite a bit longer than one meeting to get through all of them. And I'm sure there are new ones coming in as we speak, so lots to do. But thank you very much to the legal department. We're very grateful for your input.
Hello. Are you right? I would also wanted to join my co-chairperson to say thank you very much. And then also to appreciate that we have honored our request. Remember, some of you indicated in the MENCO that they might not be here, but definitely you are all here. We are so proud of that. Thank you very much. Keep it up like that. And then also, I think, may you please open your doors, because time and again we'll come and knock at your doors to seek for some advice. And also some of technically respect so that we can be able to improve our work as well. And then also to clarify something, it doesn't mean that if you are not a lawyer, you can't do something. I'll put an example for discussion of some days. We had a lot of guys from the Robben Island in particular, let me put, and also from exile. There was a debate with the honorable member, former member, Paulo Jordan. But look, how many people were able to write their exams through his input and they pass to become professors, etc., etc. No matter he was regarded as 1, 2, 3. I'm trying to say even now, the team which is here with me, no matter they don't have those status of being a lawyer or whatever, but I do trust in my team. Because it's not me, number one, first category. They were being assigned by their constituencies where they come from, as well as their parties to come here, as well as Parliament also. There is a responsibility which is given upon their shoulders for them to be here. That good guys, you form a team which will make sure that they will improve our daily lives. So thank you very much to be here. And then also, I think for you, we can excuse you, but if you wanted to remain with us, because there are 1 or 2 issues which we wanted to address before we adjourn. Sorry, there is a hand. Your hand is up. Yes, you can.
Chair, I don't know if it's possible for us to schedule a two-day meeting for deliberating on these reports because, wait, let me finish, Chair. Wait for me.
You are protected. Finish.
Yeah. Because we've just, they've been presented, here, Chair, and we only asked question, and that process consumed 4 hours. So it won't be possible for us to deliberate on 10 submissions within a day. I'm looking at the feasibility. So that we are not going to be caught off guard on that day when we are unable to complete them. I think we must be proactive in terms of our preparation. Thank you.
Okay. Before I respond, Chief, yourself,
Yeah, thank you, sir. I will support the submission by my colleague from MK. These are very hefty issues, and these issues need thorough interaction and engagement, and we cannot just rush it through. I think for people that are working in this field, they will agree that once you present something specifically to Parliament for amendment, it must stand constitutional muster. And therefore, we need to apply our minds and do thorough research. And if it's going to take 2 days or 3 days, I think we must set it aside in order to finalize on these matters. Thank you very much.
Before I open for you, colleagues, I think we have agreed that we must remain. The intention of remaining is for us maybe to have some briefings or discussions about our own program, because that one, it depends on us. And then also it depends on us. Whom are we inviting? That is going to us. But nevertheless, I've noted your hand. Your hand is up.
Thank you, Co-Chair. Chair, I think it's also very important to note for my colleagues, and it was discussed at length in our previous meeting where most of you weren't there, that this is a legacy report. So most of these matters come from 2021. This is not new items up for discussion and with regards to changes we're going to make now. This is a legacy report to show what has the committee done, and that's still on the books that we need to clear so we can get new submissions. So we shouldn't redo the work of the previous Parliament. Thank you, Chair.
Colleagues, please, I wanted maybe to request one more. Let us not open debate now. Our chance is coming for us where we are going to debate and have some of these arguments. What do we want? What, for an example, we didn't start yet to agree and disagree with the previous responsibilities. Let us leave it at the moment, and then so that we allow them, they can remain with us, but it's only few or 1 or 2 things. Colleagues, I wanted you to suggest something numbered, which we're supposed to deal with it now. I think we have done with the issue of the presentation, of which we agreed that we must have committee deliberations and over these submissions and alike. So our proposed date, it's the 28th of March. We propose that colleagues to come back here, and my emphasis, I wanted to emphasize that it's better to prepare in time. Unlike some of the people who were always crying that we inform them in a short notice and like this one, it's a long term. And then also, following date, we propose that 4th April to be a date for us to adopt some of outstanding minutes and also whatever is and also the reports on the conclusion of all legacy matters. That's where we're going to debate on the thing of the legacy matters also, that date on the 4th April. These are some of our submission and the proposal to you as members of the committee, so that you go and prepare yourself. And some of the things which are rising at the moment, they might come as well. And then again, what am I going to, what I'm requesting, please, in order to, you can't build a house in the same day. This was a first meeting, very powerful meeting, I can say like that. But what I'm trying to say is that may you please double check with the secretary whether your emails or contact numbers are correct. Because what I've learned, some of you colleagues, they do have maybe 1 or 2 or 3 cell phone numbers. The other one, you can't get the person in the WhatsApp, the other one, you can get the whatever, vice versa, so that our coordination can be very positive in terms of coordination for our meetings. Because we mustn't forget that the part of the responsibility which is given to us is so sensitive. It needs us to participate fully, and then also need us not to rush to the airport. That is a mistake. I'm impressed whereby some of the members are starting to have that oomph to propose that we have it 2 days or whatever. I'm happy. But I won't be happy if at the same time, when we agree with such an achievement, at the end, when we agree to arrange for those particular days, and the members are nowhere to be found. That is the thing which normally used to happen. I'm appealing that we must, make sure, because we had a proposal in Parliament, in both houses, in NA and NSOP, that they must reserve Fridays for us. So that is in short for me, and I'm requesting that very soon, and also to our staff. I wanted to propose something for our staff. I'll protect our members as well with that proposal. May you please make sure that the communication which you are sending to the emails or whatever gadget or WhatsApp to the members, it has reached that particular person. Why I'm raising that, remember, we are from different provinces. Besides being different provinces, we had different responsibilities, whereby sometimes we are in the places whereby there's no network. You can assume that I've sent the message, I've done all this stuff, only to find that particular person didn't receive anything. It happens. At the same time, sometimes that particular information, let's say some of the colleagues were outside of, with some responsibilities. When you come back in the morning in the flight, that's where you realize that you do have some messages with some lot of documents, you see. So what I'm proposing, as long as I'm still around next to you, I'm proposing to do dual responsibility in terms of our staff. Make sure that some of the information you send them in advance, electronical, and then if we arrive in the committee, so that our members can be fully actively participating. Because with some, maybe you made a mistake, you have your cell phone is too small to juggle around so that you can compare whatever. So I propose that to avoid some of the things which nearly happened today, that some of the colleagues didn't receive some of the information, to correct that one. That's what I'm proposing to our staff. And with that regard, I think I've tried to cover some of our concerns, that we must correct it like with way, and then also to put our members on par, that they must be ready with the amendments of the dates, because we are being directed by you in terms of the staff. Sometimes when we make a follow-up to check with the particular date, only to find that out of the numbers of the people which you are given to serve in the committee, most of them, they will be outside the country, where otherwise where. Therefore, it will make us difficult to stick in the particular date. Okay, Chief, I've noted your hand.
Thank you, Chair.
Yes.
Chair, can I just ask, this is the last question, can I just have clear-cut guidance on the, clear-cut guidance from the chairs? I understand that, as has been said earlier on, this is a legacy report. Now, if this is a legacy report, coming from 21 and so on, It's here, the co-chair said it's coming up for deliberations. If this is a legacy report, then we as committee members must understand whether resolutions have been taken on this or not. So if it's coming up for deliberations, then we emphasize our point to say we must have ample and enough time to go through this, because I didn't see resolutions being taken on this. And secondly, if this is a legacy report where resolutions have been taken already, because we need to account to our political head superiors also. If this is a legacy report that where resolutions have been taken already, then us as new members or new committee members cannot be co-opted or coerced into a situation where resolutions have been taken already. We must understand this. So whatever committee has taken resolutions in the past, we cannot associate ourselves with this. We must have clear-cut guidance. You must articulate what the position is, because we cannot just endorse resolutions of a previous committee or a former committee. So are we debating? Are we deliberating? Are we taking into consideration what we have in front of us? Is this coming up the next time for deliberation, and then ultimately conclude the process until we legislate on the process? Is that what we say? Thank you.
My hand is up.
Yes. Okay, Chief, noted.
Sorry, colleague, I mean to say, and I say this respectfully, some of us are not so elementary not to understand what is happening. We must respect the integrity and the intellectual capacity of one another here. Thank you.
Noted, Chief.
Yeah, thank you very much, Chair. Chair, I think we must not be misled here. These are outstanding submissions which were not deliberated on in the 6th administration. That is what the legacy report says. So I don't know where the honorable member takes what he has said from. Here we must be given enough time to deliberate on these submissions, and in so doing, Chair, we require enough time. We're not going to engage in a tick box exercise here to say we're just endorsing, we're endorsing. We want to engage these submissions into details, and we're saying it is not possible to do that within a day, to engage on 10 submissions. We must separate them to say maybe on one day we engage 5 submissions, and then on the second day we engage the remaining submissions. Thank you very much.
Okay, Honorable Member Kaunda.
Thank you, Chair. We'll also need to make a determination, especially on the legal advices that we have received, to see to it that where there is a need to provide stakeholders an opportunity to hear from them what are their views, then we do that before we even get into a resolution on the issues. So I think we'll need to open that space for some of those submissions. Thank you, Chair.
Honorable members, I think the response is already, the two honorable members, they've responded to the question which you were raising, that procedural it's going like this and this and this, of which, that's why we are requesting that particular dates, we must also be here to come and continue with our responsibilities. Colleagues, are we agreeing then with the 2 dates which we have proposed, the 28th March and the 4th April? Yes. I think, thank you, honorable members. I think we have agreed with the 2 dates, but in case of anything, we'll keep on updating you, and then also to address the concerns which have been raised by the members. I think there's anything, Koche?
Thank you. Yes. Well, I thought I made it clear at the beginning, but perhaps I didn't, that we would need more than 1 day to deal with these legal opinions and with the deliberations. We won't get them done in 1 day. It's not possible. So we will find another date after the 28th to deal with them. I also thought I made it clear, but perhaps I didn't, that we would have to invite public participation and other views on these matters. That will take time. We have 5 years. And yeah, so that's clear, and we'll arrange dates that suit everybody. But the availability of dates is limited to a Friday. Those are the days that are set aside for joint committees. So it's not within this committee's purview to sit on other days. We all are members of other committees that sit on other days. So availability is an issue. So we must find enough time on Fridays to deal with whatever work comes our way, and deal with it properly and effectively and efficiently and thoroughly. And there's no option about that. So for me, thank you all for coming. Thank you for the time. And thank you for staying and paying attention to the contents. And mostly thank you to the staff for the effort they've put into arranging these meetings and making sure that we have everything we need. And to the legal department again, thank you for your efforts. Thank you.
No, co-chairperson, that's supposed to be done by me, but nevertheless, I'll take it as it is.
You're welcome to add whatever you want.
No, I won't. Thank you very much. The meeting is adjourned.